Morning, we're on the record. Good morning. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with DC Code Section 2571 et seq. Of the Open Meetings Act, OMA, I'm welcoming you to the regular scheduled meeting of the Alcoholic Beverage and Cannabis Board. This meeting is being conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Electronic meetings by the ABC Board are authorized pursuant to Section 2577A of the DC Code. Pursuant to the OMA requirements, notice of today's meeting was provided 48 hours in advance of the meeting on ABCA's website and on the District Central meeting calendar. The notice included the time, date, agenda, and call-in or login information for public participation. This electronic meeting is being hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson. I'm chairperson of the board. I would like to introduce the other members of the ABC board who are also participating electronically. Please respond when I announce your names. Mr. Silas Grant.
Mr. Silas Grant, present.
Ms. Terry Janine Quinn.
Janine Quinn, present.
Mr. David Meadows.
Mr. David Meadows, present.
Mr. Ryan Jones.
Mr. Ryan Jones, present.
The board has 5 members in attendance for the conduct of business today, and that constitutes a quorum. Before we get underway with today's hearing calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There are 10 cases scheduled for our morning calendar. Once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case has not been heard, you will remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. Let's now turn to our calendar. The first case in our calendar, protest hearing status, case number 25 PRO 00010, International House of Prayer, International House of Prayer for All People, license number 130347. Good morning, Mr. Oriana. Can you please elevate the rights of the licensee and the protestant in this case?
Good morning. Morayo Ogun Pidip Me. Your access has been elevated. BJ Kapoor, access elevated. And Sean Collins, access elevated. That is all terms.
Thank you. Can everyone please come on camera? I'm waiting for the licensee to come on camera. Is there an issue with the licensee being on camera?
I just sent them a request to unmute. Morayo, are you able to click start video?
I'm trying to, let me see. Okay. Hmm.
All right, sir, if you're having technical problems, we'll move forward, but let me know.
Camera's on.
All right, well, we'll move on. Okay, sir, can you please spell and state your name for the record, and who do you represent?
My name is, okay, I see here what I was supposed to do right here. Okay. My name is Morayo Mufiditimi. I represent International House of Prayer for All People.
Can you spell that for the record, sir?
Morayo is my first name. Last name is Ogunfiditimi.
Can you pronounce that one more time for me, sir?
Morayo Ogunfiditimi.
Ogunfiditimi. Good morning, sir.
Thank you, sir.
So let's have the ANC. Please spell and state your name for the record.
Sure. Am I audible?
I can hear and see you, sir.
Perfect. Commissioner Vijay Kapoor, VIJAY, representing ANC 5C.
And the group of five or more.
This is Sean Collins, SEANCOLLINS, representing the neighbors of five or more.
Good morning. We'll start off with the licensee. Are there any preliminary matters you need to bring to the attention of the board?
No.
What about the ANC?
I just had to correct that there is, to my knowledge, no license of issuance. So I've been referring to the licensee in this matter as a protestee.
So
This is a matter of clarity.
I don't understand what you're saying, sir. What you're saying?
This is a catered site.
Hold on, sir. It's a caterer's license, and they're renewing their license, and you have protested the renewal of the license. So what are you saying?
So that is what I'm saying. There is no license. There is no renewal of a license. The catered site protests are pursuant to events where licensed caterers were present, not a license awarded to the premises.
Okay. All right. You file a protest. Hold on. Hold on. All right. So you filed a protest for a catered site. I've not had this before, but all right. So both you and a group of five or more have filed a protest to a catered.
Understood.
You have the right. You do have the right to protest this. It's a protestable issue based on the code. So I guess.
And I apologize. I do know this is a unique case. This might be the first use of these particular regulations. And so I just wanted to make sure off the bat that I clarified that so that we can try to minimize confusion, because I know it is a unique case.
Well, it's not going to be. There'll not be a problem if we go to a protest hearing. So I mean, it's a matter that all the parties can try to settle this matter. But if it's not settled, then we'll go to a protest hearing, and then you provide whatever your issues are, what it is that you're asking for, and what it is that you're asking the board to do. So
understood. Yeah. And so I will note also as another preliminary matter, I did not get that out soon enough that I would expect many folks to have reviewed it, but I do have a draft settlement agreement. In mediation, we were all amenable to pursuing a settlement agreement, but the verbiage, because again, it is a unique case, is something that I certainly wasn't sure how it would look. It was established with a back and forth with ABCA that I would be the one to draft it. And so the reason why I was so ready to make that correction is because I struggled with myself with how to take my existing ABCA settlement agreement templates that I have negotiated and change the verbiage. And so I changed the word applicant in all cases to protestee. And so that settlement agreement draft exists. I believe everyone, as recently as I know, is amenable to pursuing the agreement. I do not expect anyone to have thoroughly reviewed it, and I probably would expect another mediation session, or would request another mediation session, although I'm happy to defer to the other parties on that matter.
Well, let me, any preliminary matters you want to bring to, I'm going to address that in a minute. Any preliminary matters you want to address, Mr. Collins?
No, just to VJ's point, there's a draft of the settlement agreement now, and I think everybody's amenable to at least reviewing it and trying to get to a place of agreement.
All right. So the long and short of it is that the parties can enter into a settlement agreement. And for you, Mr. Collins, you're the group of 5 or more. Mr. Kapar, the ANC. If the ANC signs the settlement agreement, then you can either join, or if you do not join it, then your protest falls. Okay, I just want to let you know that if there's a settlement agreement that is signed, and if you don't agree with the settlement agreement, then the protest falls. Just want to let you know that. Also, the board cannot order the ANC to the board cannot order the ANC to make you a part of a settlement agreement. Okay, I just want to let you know that it's just by operation of law. And I also just want to say to you, if the settlement agreement is reached between the ANC and the caterer, I'll say it this way, and this licensee, that the group's protest falls. It's just by operation of law. So I'm just saying that hopefully the parties work together to reach an agreement. If that can be done, or if the parties, if they require another mediation, I can make sure that the agency schedule another mediation, or if you want to do it informally. But if you want the agency to schedule another mediation, I will make sure that it's done.
Then I guess we should go ahead and do that. Mariah, is that what you would agree with as well, to formally review the document that VJ submitted?
That's fine. I mean, we're okay with another mediation with the ABRA, or aside from ABRA. I think that we haven't had any problems communicating. So,
but it's up to you. If you want us to, you can reach out to the mediator to schedule it, or I can have them contact you. So it's up to you. If you want another formal mediation, this is something that the agency we can accommodate. So we're here, and you can also reach out to the agency. Yeah. So you can either reach out to the mediator to schedule another mediation, or I can have them reach out to you to schedule one if that's what the parties desire. And we'll make sure that happens. If this matter is not settled, the protest hearing is scheduled for September 24th at 1:30 p.m. I guess let me ask the parties, do you honestly believe that this case will be settled, or will it go to a hearing?
I'm optimistic that we could have the settlement agreement executed by September 24th.
Well, the reason why I'm asking it is because if this matter is going to go to if this matter is going to go to hearing, then we need to assign an investigator to the case. So to contact the parties to see what the issues are, draft a case report. So that's why I'm saying, if you do not believe, and all of this, and then on or before September 17th, which is 7 days before the hearing, you would have to provide the PIP. So the PIP is a document that, I mean, are you familiar with the protest proceedings if we're to move forward to a hearing?
No.
No? All right, so I'm going to read, all right, so this matter, I'm going to read the guidelines. So this matter then, if it's not settled, will be scheduled for a protest hearing on September 24th at 1:30 p.m. Okay? All right. Now that we have scheduled this matter for protest hearing, there are a few things that I would like to instruct the applicant and the protestant, the licensee and the protestants, about the protest hearing to ensure that the protest hearing is focused and addresses only those issues that are being protested. The board does not intend to hear testimony on matters that are not relevant to this case. You should have received by electronic or regular mail a letter explaining the protest process, a copy of the protest information form, and a copy of the exhibit form. If you do not have these documents, please contact our legal office and we'll provide them to you. It is imperative that you review the rules closely and adhere to them before and during the protest hearing. You're also required to complete and submit the protest information form PIP and the exhibit form 7 days before the date of the hearing. These two forms and accompanying documents need to be submitted to ABCA's legal division and to all opposing parties in this matter. If we do not receive a copy of your PIP, your application or your protest, whichever side you're representing, may be subject to dismissal. Likewise, if we do not receive a copy of the exhibit form and the exhibits themselves, your exhibits may be excluded from the record upon a finding that the opposing party has been prejudiced or no good cause for failure to submit has been shown. Likewise, witnesses other than a party may also be subject to exclusion if not identified on the PIP. Accordingly, these forms are very important. They greatly assist the board in narrowing the protest issues, facilitating the process, and keeping the parties on point during the hearing. They likewise provide notice to the opposing parties, enabling them to better prepare for the hearing. As you're aware, all our hearings are now conducted virtually. You will have 90 minutes to present your case, and you will only be allowed to call 5 witnesses. For cases such as this one, where there is more than one protest group pursuant to section 1612.8, the board is requesting that the protestants designate one individual to represent the group protesting the applicant. So basically what that says is that although this matter has been protested by 2 groups, if this matter goes to a protest hearing, then both the protestant, the group of 5 or more in the ANC, they would have to determine who is going to represent the parties' joint interests at the hearing. Okay, but I'm hoping, so just want to let you know, if you have any questions, you can reach out to our legal office. We'll provide the guidance that you need. If you you can also, as I said before, if you have a settlement agreement, you have any concerns about what are some of the terms, you can also reach out to our legal office. We can provide whatever assistance that you need, if the parties truly believe that this matter will be settled. Okay. Any questions?
So just to be clear on the timeline.
So 7 days before the hearing, if this matter is going to go to a hearing, 7 days before the hearing, and so this hearing is scheduled for September 24th. So that's September, I think, 17th. If I look at if I'm reading the calendar, 7 days before the 24th.
No, I understand.
No.
My question is if we were to have another mediation session before then, that would get scheduled. And if we agree on the settlement agreement that's drafted at that time, we wouldn't need to appear at the protest hearing. The issue would be resolved. But that's if, when we contact and are able to schedule something in between that, in that window the next month.
Or if the parties truly believe that this matter will be settled, and so if you need some more time, I'd say, for example, I don't know what the schedule for the ANC. If there's a settlement, the ANC would have to take it to. I'm not sure if they would have to take it back to their meeting to. Okay, so all right, so I don't. But if the parties believe that this matter will be settled, and if we could continue the hearing, you could file a joint motion to continue the hearing on the 24th. So we don't have to have the hearing on the 24th if the parties mutually agree that they want to postpone it so they can continue talking because they believe that this matter will be settled. All right, but the parties would have to mutually agree to ask the board to formally request the board to continue the date of the 24th. But as I stated before, if you can reach back out to the mediator, and she will schedule another meeting at the convenience of the parties to see if this matter can be settled.
I'll reiterate, I'm optimistic, and I know we had a gesture back and forth, Mr. Chair, but to reiterate, I am authorized to execute a settlement agreement on behalf of ANC5C in this matter.
No, that's fine. I said I wasn't aware of the procedure if you had to go back to the ANC. That's what I was
Completely
thinking.
understand. I just want to make that would be a very large risk that doesn't apply in this case, and so I remain optimistic. And so I'm hopeful. We all take that September 17th is our deadline before that other set of follow-on work. And so I'm optimistic, and we've already been in contact with the mediator, with Ms. Fletcher, and we're going to schedule another mediation session.
All right, fine. Well, good luck with your discussions, and I hope that this matter can be settled. The board prefers settlements because if there is a settlement agreement, then both parties will leave satisfied with the results. When we have a hearing, one side might be happy, the other side might be unhappy. So that's one of the reasons why I prefer for the parties to settle the matter if it can. If it cannot be settled, then the board will make a determination. Okay? All right. So thank you very much for your participation today. Have a great day. All right. The next case in our calendar is case number 25, PRO 00043, Eaton DC Allegory, Wall Days, license number 123549. Mr. Oriana, good morning. Can you elevate the rights of the licensee and the protestant in this case?
Good thing. Michael Schenkel, access elevated. Brianna Bates, access elevated. And Matt Menora, access elevated. There's all terms.
Thank you. Mr. Menora, good morning.
Good morning.
Can you spell and state your name for the record, sir?
Sure. My name is Matthew Menora from the law firm of Malleus O'Brien and Sandground, and we're ABC licensed counsel for the applicant. My name is spelled Matthew-Minora.
Is your client here this morning, sir?
No, I'm representing the client myself this morning.
All right, so I'm trying. Who is Miss Bates? Miss Bates, can you please spell and state your name for the record, and who do you just tell me your role here, please, ma'am?
Sure, I'm the protester. I'm an owner at 1150 K Street Condominiums, representing the community. My name is spelled Brianna Bates.
So are you a group of five or more or a butt-in? Which one are you?
Group of 5 or more.
Okay. Mr. Schenkel, can you please spell and state your name for the record?
Good morning. My name is Michael Schenkel. I'm the chair of ANC2C. My name is spelled Michael, last name Shankle.
Mr. Menor, are there any preliminary matters in this case?
Yes, as of this morning, the ANC and the applicant have come to a second agreement to the settlement agreement to resolve these issues, and we're just waiting for execution and then submission of that second amendment.
Mr. Schenkel, Ms. Bates, that's the representation?
That is correct. This was done in collaboration with the group of 5 or more.
Well, thank you for that. This matter is scheduled for a hearing on September 17th, but if this matter truly going to be settled, just advise our agency as soon as possible that this matter will be settled, so we do not have to assign an investigator to do a case report. I'm glad to hear that the parties are able to meet and agree to mutually satisfactory terms. Okay, all right.
Great.
Thank you.
Thank you for
very
the
much.
representation. Art, have a great day.
Thanks, you too. Bye-bye.
Bye-bye.
Thank you. Bye-bye.
Okay. The next case is case number 25 PRO 00062 El Canale, license number 83707. Mr. Oriana, can you please elevate the rights of the licensee and the protestant in this case?
Don't see either. I'm ask in the chat.
Trust me, they'll be here. So
Yep, you're right. Manala Mahmood, access elevated. And I'll check on John Uhar. There is a call-in user. I'm not sure if it's the court reporter, but I'll elevate just to check.
can you find out who the call-in user is, please? Call-in user, can you identify yourself? I'm trying to find who the call-in user is. Can you unmute yourself and identify yourself?
John Uhar here.
All right. Thank you. Ms. Mahmood, good morning. Can you please identify yourself for the record?
Hi, good morning, Mr. Chair, members of the board. Manal Mahmood with Malleus O'Brien Sandground on behalf of licensee MANALLE-MAHMOUD.
Good morning. Mr. Huar, can you please spell and state your name for the record, sir?
Yes, my name is John Uhar, John Uhar. Uhar.
Good morning, sir. Ms. are there any preliminary matters in this case you want to bring to the board's attention?
No, Mr. Chair, we attended mediation and were unable to resolve this dispute.
Mr. Huar, are there any brief preliminary matters you want to bring to the attention of the board?
Yes, there is. I believe that the evidence that I presented, as well as the fraudulent board check sheet that you gave to me, are such that the operation of law should require the revocation of Il Canale's liquor license without any further ado. And I pointed this out repeatedly to you, to the board, to Mr. Mussolini, and even if we were to assume that he did have a valid check sheet or settlement agreement, he's constructed structures that interfered with public access to the alley without a permit issued by the appropriate DC agencies. He's constructed unpermitted structures in the alley that block access to the backyards of any resident. And these have been since the most recent fraudulent settlement agreement. And after 4 days, these Tier 2 become Tier 1 violations with fines payable at $4,000 a day. And the operation of law would instruct most people to investigate and enforce.
All right, Mr. Uar, I asked for preliminary matters. These are more substantive matters that you're raising, and as you're aware,
No, sir, they're not. You've been actually okay. Let me go to preliminary matter number 2. This Mr. Ferruggio's father, you and the OAG have been able to keep in the DC Court of Appeals since 2019 through various DC ABCA boards and appeals and this and that. Now I have the son when his father's still hasn't been decided for the same proof of evidence that I presented here. I don't understand what is the objective of the DC ABCA board to give a license to somebody whose father is already tied up in litigation.
All right. Do you have another preliminary matter, sir? You want to put on the record, sir?
No, I just would say the operation of law makes all these things incumbent upon you or your superiors with reference to the United States attorney for the felonies that have been committed and the crimes that have been committed against me for a long time. Not just me, my neighbors, my family. I got to put my place in the country up for sale. I can't hang around next to this man because you don't do your job and you don't tell him that he can't build a summer garden over a public alley. The ANC and the CAG giving away my rights and my neighbor's rights to the alley, and then have Mr. Berman tell me that ANC and CAG agreements are like diaries. I don't know why we're here. That's all I can say.
Well, sir, this is a protest hearing because you filed to renew the license and you have protested the renewal of the license, sir. So we are here based on the protest that you have filed. Okay. All right. That's the reason
correct.
why
But
we're
you wouldn't. We wouldn't be here if you would investigate the evidence.
Well, sir,
You have not refuted any proof. No, you gave me a board order that told me that, oh, this is unsubstantiated. Well, it's unsubstantiated and it's unadjudicated because you refuse to adjudicate.
All right, sir. The board, a lot of the issues that were raised, we have addressed those issues previously, and you are aware that if you disagree with the determination made by the board, you can appeal this matter in Superior Court, which you have done. So as I stated before.
No, sir. It's the D.C. Court of Appeals, and I spent a lot of money because you wouldn't consider the evidence and enforce the subpoenas of those who could tell truth about the frauds that were committed against D.C. agencies. And now we're here with the son. So just keep telling me why we're here. So when we go to the Court of Appeals again, that you can burden so Ilk and Alley can keep operating. You know, at least at some point, it's all going to come due.
Well, we're here today, sir, because they have applied to renew their license, and you have protested the renewal. So that's why we're here today. But anyway, but that's where we are, and the issues that are being raised, they will be addressed either if you file motions, the board will review and respond, and if not, we will move forward to a protest hearing. So this matter is scheduled for a protest hearing on September 17th at 1:30 p.m. I just want to advise. Yes, sir.
Could I say something? Why don't we have the protest hearing after legal officer Berman's been? Why doesn't he just go through his records and try to disprove the prima facie res ipsa loquitur evidence, and then once he does that, then we can go to the protest hearing. The proof's already there. You didn't hear it the last time. You won't hear it this time. You'll try to burden the Attorney General and, the Court of Appeals. That's how you guys roll.
All right, so as I stated before, this matter is scheduled for protest hearing on the 17th. If parties if the parties jointly file a motion to postpone this matter, the board will consider a joint motion to postpone this matter, okay? So as stated for this matter scheduled for protest hearing on September 17th at 1:30 p.m. Just want to remind the parties that if this matter truly goes to a protest hearing, 7 days before the hearing, the parties are required to provide a PIP to disclose the documents and witnesses that they will rely upon at the hearing. Failure to do that, the board is empowered to prevent that side from relying on documents that have not been previously disclosed. Any questions?
No, thank you, Mr. Chair.
Yes, Mr. Huar, any questions there?
Yes, again, there's been some false testimony entered into the record by the attorney, Mr. O'Brien, for the applicant, and several pieces, and I've requested that be redacted from the record, but Mr. Berman says that the DC applicant cannot address perjuries by attorneys in front of the board. And I was just wondering what your opinion on that was, because again, these are just positive to the case.
I don't have an opinion, sir. The opinions are determinations that are made by Mr. Berman, our general counsel. It is all with the consent of the board. So whatever decisions that are issued, whatever motions, whatever written opinions that are issued in this case, that is the position of the board, sir. Okay? So as I stated before, this matter is scheduled for a protest hearing on the 17th. If the parties jointly ask us to continue this matter, we'll do that. If not, we'll see you on September 17th at let's see. So it's September. Hold on 1 minute, please. September 17th at 1:30 p.m. Okay.
Thank you, Mr. Chair.
Thank you.
Okay,
Have a great day.
if you want it looks like we're going to just burden the court again, the appeals court, but hey, you get another 6 years for the sun, what's going to happen, you know? Worth it, right?
Thank you. Have a great day. The next case in our calendar is case number 25 PRO 00075 BNB, license number 1325883. Mr. Oriana, can you please elevate the rights of the parties in this case?
Good thing. Daniel Obogwe, access elevated, and that appears to be all, Chairman.
Is Mr. Jackson available? Can you see if you'll find Mr. Jackson?
Yes, checking in the chat. No update, Chairman.
Okay, fine. All right, let's Mr. Aboge. I apologize, sir. Can you please spell and state your name for the record, and who do you represent, sir?
Sure. Good morning, Chairman and members of the board. This is Daniel Abawaji, and that's spelled DanielAbaoAGYE.
And who do you represent, sir?
And I represent the group of 5, the Protestants.
Were you expecting Mr. Jackson here this morning?
I believe that he had mentioned yesterday during the mediation hearing that he has jury duty today, but he did mention that he expected the applicant to be here because of that. So I'm not sure if the applicant is here.
And who's the applicant?
Miss Zebene.
There's the Miss Zebene. Okay, she's online.
Zebene.
Okay, ma'am, can you come on camera, please? Please unmute yourself and come on camera.
I just sent them a request to unmute.
Thank you.
It appears they're on a mobile device and they may be away potentially.
All right. I'm
Hello?
I'm sorry. Can you please spell and state your name for the record, ma'am?
Okay. Good morning. My name is Venus, VENES ZEBENAY.
And what is your relationship to this case, ma'am?
It's the owner of the application.
Okay. Good morning, ma'am.
Good morning.
Are there any preliminary matters that you need to bring to the attention of the board?
Mr. Chair, I would like to bring up a preliminary matter. During the mediation hearing yesterday, there was an irregularity that brought some concerns to the surface for us as protestants. An individual named Mr. Windim Demisi was participating in the mediation as the interpreter for Ms. Zebene. That individual, however, is not trained as a professional interpreter. They are, in fact, the owner of the building in which the business is going to operate out of. And based on the way that the mediation was conducted, we were not confident that they were acting in the role of a translator. It seemed as if at times they were speaking quite obviously for themselves, and they have sort of a direct interest in the outcome of this protest, in particular the management and operation of the business. And we're not sure what the relationship between those two individuals is and the companies that they represent, and that being that Sophie Inc., DC, and 1447 LLC. Given that conflict of interest that seems to exist there, we don't feel that it was appropriate for him to act as the translator for that mediation session. We didn't get the sense that our words were being communicated to the applicant in Amharic. We never heard rather him actually do that. We in fact got into several exchanges that were clearly him interjecting his own opinions into the discussion and sort of steering the discussion based on his own interests. That raises for us concerns related to DC 25-301 and 302, which is just that all parties that have a financial interest or substantial operational control in this business should be disclosed on the application. And we're not confident that that has happened in this case. And so for procedural purposes, we'd like to move for the board to compel a disclosure of the operational and management and ownership interests, in this case, the full disclosure thereof, in order to get that on the record.
All right, hold on 1 minute, please. All right.
Mm-hmm.
We provide translation services to anyone who asks. If the licensee has not requested from us that she needs a translator, the government cannot provide a translator. The licensee can, if they can designate whoever they believe that they want to speak for them. So that is not something that the board can get into, sir. So if they have,
It's not. Sorry, go ahead.
But I'm just saying you're stating that it's your opinion that whoever was translating for her wasn't translating appropriately,
Well,
because
sure.
but I just want to let me.
Mhm.
We provide translation services to everyone who asks. If the
Mhm.
licensee hasn't, if they don't request from us that they need a translator,
Mhm.
the board cannot do that, because we believe that English is not there. Because we believe that because we believe that English is not their first language, so they require translation services. So the
Mhm.
board cannot get the board. That's not an issue that we can address, sir.
Sure. Yeah. No, that's not what we're asking.
And I know we're having this conversation. I don't know if she understands. It's my understanding that she has a representative who's Mr. Jeff Jackson, who's not here today because based on the representation that he's on jury duty. So I hear what you're saying, sir, but that is not an issue that this board cannot
Sure.
respond to.
And we're not asking at all to respond to the issue of the interpretation services. What we're asking for is a full disclosure of the financial interests and the ownership interest in this business under DC 25-301 and 302, which is something that the board has an interest in, that all parties are disclosed that have a significant financial or managerial operational control over this business.
Well,
We
that's
don't.
not what the law requires. That if you at least in in alcohol matters, if you own more than 10%, you have to be on the license. If you don't own more than 10% of the business, then there's no requirement for you to be listed on the licensor. So
Mhm.
I don't know. You're saying someone else that all we can go by is
Mhm.
the application. The application itself lists
So
who the owners are.
in the matter of S&G Wine and Liquors, which this board moved pretty decisively on in 2021, which actually happened to deal with this same individual, Wundim Demisi, in which a cease and desist order was issued that stopped all operations for business that the board determined through their investigation that he was operating, although he was as an owner or controller of the business, despite not being the applicant, and even referred that order to the attorney general for prosecution. And that was just in 2021. In that case, the board, I think, held pretty strongly that based on DC 25-301 and 302, that it is in the interest of the procedural integrity of the licensing process that all parties be disclosed that have an ownership interest in the business, and that the law provides for that.
Well, I think I'm not off the top of my head, sir. I am not familiar with the case, but there's no evidence. Listen, sir.
Mhm.
There's no evidence here that the individual that you're referencing is operating or has presented him or herself to the board as the owner of the establishment.
And we have that evidence.
But this is not the forum for that.
Mhm.
We have the owner. I mean, we have the owner. We have Miss Zebane here as the owner. She's presented herself as the owner, and if you believe that she's not the owner, that's something that either you file a formal complaint, but that's not an issue that and that's not an issue that can be addressed here at this juncture in
Sure,
a protest
and
hearing, sir.
we totally understand that. What we will ask is that we plan to submit a supplementary protest filing, and with that to also include a motion to compel disclosure. I think that both of those things are processes that exist that the board can take action on. And so we understand that that won't happen today at this hearing, but we have those documents and we're prepared to file them with the board, as well as exhibits that provide supporting evidence for this for these allegations, because there is substantial evidence that suggests that this is something the board should look into, and something the board has looked into in the past and found evidence of wrongdoing.
Miss Zebane, is there anything, you don't have to respond to what was just said, ma'am, but I'd ask for preliminary matters. Do you have any preliminary matters you want to bring to the attention of the board? Ms. Zebane.
Yes.
I guess do you have any preliminary matters you need to bring to the attention of the board?
No.
All right. Just as an FYI, sir, you cannot add more protest grounds. You can file a complaint, but you can't add more protest grounds. Once the matter is placarded, you had a finite period of time to file a protest. You had specific grounds to file the protest.
Well,
And
we're trying to do that under DC 25-433.
I know you can. I'm just saying that generally, you can file a motion, and the board will review the motion and make a determination whether or not it's a viable motion. Okay, that's all I'm going to say.
That's
All right.
And we plan to do
All
that within the code that is provided by the agency. We totally understand that.
All right, it's fine. If this matter goes to a protest, this matter is scheduled for protest on September 17th at 1:30 p.m. Just want to advise the parties that 7 days prior to the hearing, the parties are required to file a PIP. Failure by either side to disclose the documents and witnesses that they will rely upon at the hearing, the board is empowered to prevent that side from relying on those documents. All right, I want to let Miss Zebany know if you require a translator at the hearing, please make a formal request in writing to the board, to the agency, that you need a translation, someone to interpret for you, and what language. Okay, ma'am?
Okay.
All right. So if
Yes.
this matter's not settled, then this hearing is scheduled for September 17th at 1:30 p.m. Okay?
Okay.
Okay.
All right. Thank you. All right, the next case on our calendar is case number 25 CIT 00082 Ivy City Smokehouse, license number 112220. Good morning. Can you, Mr. Orena, can you please elevate the rights of the government, and the licensee in this case?
Sure thing. Alicia Hogan-Miller, access elevated, and that appears to be all, Chairman.
All right, thank you. Good morning, Ms. Hogan-Miller. Can you identify yourself for the record, please?
Good morning. Assistant Attorney General Alicia Hogemiller, ALYCIA HOGENMILLER, on behalf of the government.
Good morning, ma'am. I see the licensee is not here today. Were you expecting the licensee to appear? I know that licensees it's not required for them to be at show cause hearing status.
I spoke to him this morning, and no, I do not believe he'll be here. The parties have come to an agreement, and we'll file a OIC agreement for the board's review and approval.
Okay, well, that's fine. If this matter is not settled, then it's scheduled for show cause hearing on September 17th at 10:30 a.m. Okay? All right, thank you. All right, the next case on our calendar is case number 24 CIT 00452 Baby Shank, license number 121545. Mr. Orion, can you please elevate the rights of the licensee in this case?
No licensee, Chairman.
All right, thank you. Ms. Hogan-Miller, can you please identify yourself for the record?
Assistant Attorney General Alicia Hogemiller, ALYCIA HOGENMILLER, on behalf of the government.
Good morning. The licensee is not here. However, there's no requirement for the licensee to appear at a show cause hearing status. All right, this matter is scheduled for a show cause hearing on September 17th at 10:30 a.m. Just want to advise the parties that 7 days prior to the hearings, the parties are required to disclose documents and witnesses that they will rely upon at the hearing. Failure by either side to disclose documents and or witnesses 7 days before the hearing, the board is empowered to prevent that side from relying on documents and or witnesses that were not disclosed 7 days prior to the hearing. All right, thank you very much. All right, the next case on our calendar is case number 25251-00007 Anejo Bar and Lounge, license number 116070. This case has been canceled and offer in compromise has been submitted to the board for its review and consideration. And we have the summary action matter. Are you the attorney for those cases, Ms. Hogamila?
Yes, I also have a co-counsel, Xenia Laws.
Okay, fine. All right, so all right. So the next case on our calendar is case number 25, ULC 00042, Temple of Golden Teacher. And Ms. Dorian, can you please elevate the licensee in this? I think is this or I'm not sure if this is a summary action. So is this a licensee? No, I don't think it's a licensee. The
It's an
unlicensed
unlicensed
establishment owner.
establishment.
The owner of this establishment.
Sure. Joel Braithwaite, Access Elevated, as well, Chair.
All right, thank you. All right.
Good morning, Mr. Chair and the board. This is Joel Braithwaite on behalf of the Temple of the Golden Teacher.
Hold on, sir. Do you have a camera you can turn on, sir?
Yes. Good morning. My name is Joel Braithwaite. I'm appearing on behalf of the Temple of the Golden Teacher.
Hold on 1 minute, please, sir. Hold on, please. Let me start with the government. Ms. Hogamiller, can you please identify yourself for the record?
Assistant Attorney General Alicia Hogemiller, ALYCIA on behalf of the government. I'm here with my co-counsel.
Ms. Wilson, can you please identify yourself for the record?
Good morning, Xenia Wilson Laws, ZENIAWILSON Laws, LAWS.
Good morning, Mr. Braithwaite. Can you please spell and state your name for the record, sir?
Good morning. My name is Joel Braithwaite, JOELBRAITHWAITE on behalf of the Temple of the Golden Teacher.
Good morning, sir. Is your client going to be here today, or are you the only representative here this morning?
Today I'll be the only representative.
All right, thank you. All right, now this is a summary action motion, so maybe the government can set the stage. Why are we here?
Chairperson Anderson, this is a summary closure of an unlicensed establishment that was found to be selling Schedule I drugs, psilocybin. So we're here today on, the government will ask that the board affirm the summary closure and continue the summary closure. We have witnesses to present.
Okay, that's fine. Hold on. All right, so before Mr. Braithwaite, I think you stated that you don't have any witnesses. Is that correct? You're the only person who are here today?
Yes, Your Honor, but I have submitted a motion to dismiss this summary action based on violations of the Religious Freedom Reformation Act and the establishment clause of the First Amendment, in addition to Initiative 81.
I guess does the government have a response to this motion?
Yes, Chairperson. The government is prepared to argue the motion if the chairperson would like to hear arguments right now.
I guess the question I want to ask you, Mr. Braithwaite, you filed a motion, but you don't have any witnesses this morning. So what is it that you plan to rely on as far as your motion is concerned? I mean, an attorney can only make arguments. An attorney cannot testify. So tell us, how is it that you plan to defend your motion?
The motion is defendable in three parts. First, OAG argued that you were without jurisdiction to hear a RFRA complaint. They argued that I didn't know who would have jurisdiction, but they suggested that this board doesn't have the jurisdiction to hear an RFRA
Objection.
What's the nature of your objection, Ms. Hogamiller? I'm trying to get a clarification where we're going this morning.
Mr. Braithwaite's statements about what arguments OAG would make were discussed during settlement. So the OAG would object to any settlement discussions being discussed on the record or presented to the board.
All right, Mr. Braithwaite, you are, as an attorney, you are aware that we do not have settlement discussions at a hearing. So I don't know what's going on. So, but I just want to just caution you that you cannot discuss settlement discussion. So I'm just trying to find out where we're going this morning, sir. Go ahead.
As a jurisdictional matter, if the Office of the Attorney General is stating that this board doesn't have jurisdiction to hear a claim, that's not about settlement. That goes to the very heart of the matter in the proceeding that we're here for today. This is an enforcement action by ABCA, and this is the board that is authorized to hear those enforcement actions. I do believe that the United States Constitution, the First Amendment, and specifically the precedent of the United States Supreme Court mandates that this action be summarily overturned. We have our arguments. We have presented those arguments. We are prepared to move forward, and we are of the opinion that you do have jurisdiction. So to the extent OAG has changed its position, it is okay. But I would argue that you do have jurisdiction to hear this, and if we even accept the facts as the government presents it as a matter of law, once they're put on their witnesses and once I'm able to cross-examine them, the board will soon see that none of the constitutional practices were followed in this matter.
Chairperson, may I respond?
Yes, ma'am. Go ahead.
The board should reject the establishment's motion to dismiss for 3 reasons. First, the board does not have jurisdiction to determine a Religious Freedom Restoration Act or a RFRA claim. Agencies are a creature of statute and thus cannot act outside of its statutory authority. The board must decide the case, quote, in conformity with the provisions of the statute in question and nothing more, unquote. And this is from DC Office of Tax Revenue versus Schuman, 82nd Atlantic 3rd, 58, DC 2013. If you look at the RFRA statute itself, it says a person can assert a claim or defense in a, quote, judicial proceeding. And this is 42 USC 2000 BB-1C. This is an administrative hearing, not a judicial one. And so for the board to decide this summary closure case on the RFRA factors, or even looking to the First Amendment, these same arguments still apply, and look at those factors and not based on DC Code Section 7-1671.08, which is the summary closure provision, which says that the board must uphold a summary closure if the establishment's practice and continued operation would present an imminent danger. To do so would be the board acting beyond its legislative authority given to it in these summary closure proceedings. Second, even if the board was to consider the RFRA claim, which looks at a establishment's sincere religious beliefs, this establishment religious claim is nothing more than a commercial transaction cloaked in religion. The evidence that will be presented during this hearing will show that this establishment was operating as a store, not a church. This is similar to cases you've heard in the past about cannabis establishments selling art and receiving cannabis as a free gift with purchase, which was just a cover for them to have commercial transactions involving cannabis. Courts have not extended RFRA protections to defendants where they were engaged in the commercial sale of marijuana and not actually a religious practice. And this is a fact-specific question, which would require presentation of testimony evidence by the government's witnesses. Third, even assuming the establishment's religious belief is sincere, ABCA has a compelling interest in enforcing its cannabis statutes. ABCA has a compelling government interest in preventing the distribution of psilocybin, a Schedule I drug, in a storefront, which is where this establishment was located. First, there's an interest in not allowing the diversion of Schedule I drugs to the general public, and especially to children. And this is a concern in this case because not only was the establishment distributing just mushrooms, but also psilocybin in the form of gummies and chocolate. And second, in operating out of a retail space, it's misleading the public into believing that mushrooms are a regulated industry, similar to what we now have with cannabis, and that allowing the establishment to continue operating at a storefront would mislead the public into believing that mushrooms are tested and safe to consume. In talking about the least restrictive means, Nesbitt versus United States said, quote, other courts have explicitly rejected the claim that a religious exemption is a viable, less restrictive means of enforcing the marijuana prohibition, unquote. Taking all this together, first, the board should not be adjudicating this case based on RFRA or the First Amendment based on its limited authority. But second, even looking to those claims, it would be appropriate to uphold the summary closure because this place was operating as a commercial business. Thank you.
Might I respond, Mr. Chair?
Sure, sir. Go ahead.
Now that OAG has come on the record and stated that you are without jurisdiction, I would ask that you do assert that you do have jurisdiction as a preliminary matter. That's a threshold inquiry as to whether you have jurisdiction or not. Here it is that the board sits and adjudicates cases dealing with unlicensed marijuana services. You will note that in the evidence that will come forth, less than 1 ounce of marijuana for personal use of an employee on site was confiscated. And that is how they're trying to get the nexus into any discussion of marijuana. But we will all admit that less than 28 grams of marijuana for personal use is not a criminal offense in the District of Columbia. Second, District of Columbia voters have passed the Ethnogenic Plant and Fungus Policy Act of 2020. It is codified in DC law, and it says that the Metropolitan Police Department's lowest law enforcement priority shall be accorded to non-commercial planting, cultivating, purchasing, transporting, distributing, possessing, or engaging in practices with psilocybin mushrooms. In the very name of the act is the word entheogenic. Entheogenic, as defined by Merriam-Webster, states a psychoactive hallucinogenic substance or preparation such as psilocybin or ayahuasca, especially when derived from plants or fungi and used in religious, spiritual, or ritualistic context. OAG now supposes that it has the authority to tell the people of the District of Columbia what is or is not a religion. OAG has just stood here in an argument, rejected the fact that the Temple of the Golden Teacher can, in fact, be a religious entity, despite the IRS determination, despite the fact that it's a nonprofit, despite the fact that it's formally incorporated and acting as a religious entity inside the District of Columbia. So this case places before you a central question. Is the religious use of psilocybin non-commercial? Because if it is, then what is the import of Initiative 81, which deals with entheogenic substances? And then secondly, if you find that there's not an exemption for non-commercial, and these are literally the words of the statute, but non-commercial use of psilocybin, then you must decide whether the actions of the MPD in padlocking and seizing all of the sacraments, the mushrooms, comports with the United States Constitution. There are enough legal minds on this board with enough training and expertise as qualified lawyers in the District of Columbia to assess and write a proper opinion about the import of Initiative 81 as it complies with the law enforcement authority and the facts, and whether the facts and the inquiry that the District of Columbia undertook is in keeping with the laws and the precedent from the United States Supreme Court. That is what I'll call upon you to do here today. There are 3 Supreme Court cases on point with the actions taken by MPD, and each of which shows separately that the summary closure of the temple constitutes a substantial burden on religious exercise, such that banning sacramental Schedule I use of by the temple is a substantial burden which triggers RFRA scrutiny. So there's no question that that is a fact, that if we are a temple and you ban the use of Schedule 1 drug, then you have burdened our religious exercise. Now, what's important about this is the Supreme Court case O Centro, which is 546 USC at 423 to 424. The United States Supreme Court literally allowed DMT, a Schedule 1 drug, to be used in as a religious sacrament for a particular church. So that OAG sits there and says to you that you wouldn't have the ability to do it when the Supreme Court of the United States does in fact allow for exemptions from the federal law for the purposes of religious sacrament. I think that that is meritless, and I think that is controlling law upon the District of Columbia. Secondly, you have cases such as Hobby Lobby. In Hobby Lobby, they determined that the RFRA requires the government to use the least restrictive means of furthering its compelling interest. Now, let me ask you this. If the sacrament that people receive are limited to personal quantities, it is gained from the temple, and it is, the MPD will testify it's a commercial transaction. But what we will show is that as in the base of this religion, the use of these mushrooms and the sacramental psilocybin is the very thing that requires protection by not only the United States Constitution and the First Amendment right to free exercise of religion, but also from this government action. You see, DC is in a proverbial trick bag, because Initiative 81 gives the individual the right to use and possess these drugs, these Schedule 1 drugs. And in the same quantity, if the temple distributes the same drug, and we will submit that religious purposes are non-commercial by definition, such that this squarely falls within this Initiative 81 safe harbor. There's no way that they can argue that we are somehow a threat to public safety, where they've had no discussions of people being overdosed or receiving a bad sacrament from the temple. There's not a discussion of any of our products being diverted to minors. You would see in the very testimony from the police officers that there's an age restriction and people are ID'd and they must actually join the church prior to being able to receive sacrament. So there are all these precautions that are taking place, which are more restrictive than what someone in the Initiative 81 will have access to. And yet still DC is feigning a public interest, a compelling public interest in having a religious organization, nonprofit, not be able to receive a donation in exchange for the sacrament. Now, what's important here, there's another Supreme Court case called Fulton versus the City of Philadelphia. And that's 593 US 522. And the court held that where the state has a system in place for individual exemptions, it may not refuse to extend that system to cases of religious hardship without a compelling reason. In the face of Initiative 81, which allows for the personal possession of psilocybin, a Schedule 1 drug, how can the district now tell you that the religious possession of that same psilocybin and distribution of that same psilocybin, which in non-commercial uses is actually exempt under DC law? How is it that it's more compelling when it's in the hands of a church or religious temple as opposed to when it's in the hands of the individual? We have already determined from the findings that this Schedule 1 drug is used in rituals, it's used in religious purposes, it does not possess a high ability for substance abuse or overdosing, it does not pose a substantial risk to public safety. And yet still the District of Columbia stands here and against the very law that the voters of the District of Columbia voted for is trying to make the argument today that it is exactly the opposite of what the truth is. The District of Columbia in particular is in a particular place where ipsa dicta, someone says that there's a crisis, does not mean that there's a crisis. This is what's going on here. And if you were to hear the evidence today from the Metropolitan Police Department, and after the cross-examination, you'd be thoroughly convinced of one thing and only one thing only, that this summary closing cannot stand.
Chairperson, may I respond?
Just a minute, just a quick question. So is this a Schedule 1 case or is this a cannabis case? Which one is it?
A Schedule 1 case under.
Okay, go ahead. You go ahead.
Okay, so there were a lot of arguments from opposing counsel, but I'll summarize it in 3 points. First, the board does not have the authority to decide a RFRA claim. This is a federal statute, and even in the statute, it discusses how someone can bring a claim in a judicial proceeding, a claim or defense in a judicial proceeding based on a religious exemption. In the case that opposing counsel cites, Ocentro, even they acknowledge that the courts are the ones who can provide this religious exemption. And as the ABCA board is an administrative body, it cannot make these determinations today. And so therefore, the board does not have the authority to dismiss this case based on RFRA or decide it on RFRA. It should decide it based on the DC code and whether this establishment presents an imminent danger. Second, opposing counsel speaks a lot about Initiative 81, but he puts too much reliance on that initiative. If the board looks at the initiative, it talks about how it is the desire for the people of the District of Columbia to have a policy that enforcement of consumption of ethnogenic plants would be the lowest enforcement priority. That is not an outright ban, and is not a safe harbor as opposing counsel discusses. You can clearly contrast that with the cannabis law that does provide an express exemption for personal use of cannabis. And it says the exact amount and the circumstances that people can either use or grow medical or cannabis. And this ethnogenic statute, Initiative 81, doesn't provide a similar safe harbor as opposing counsel discusses. So based on that, there's no reason to dismiss this action. Lastly, everything else that opposing counsel discusses is a factual question. Therefore, we should proceed to the evidentiary hearing that is scheduled in this case and hear from witnesses to make the determination and for the board to see that this place was acting as a commercial space. Thank you.
Do you want to respond to? I'm actually going to go into executive session to consult with our lawyer. So before I do that, is there anything that you want to say?
So I have submitted a written motion with exhibits for your review in your executive session. And I would note that I have done my best to elucidate not only DC law and the purposes of the vote, the intent of the voters in creating the act, but even also statutory construction, such as the name of the act, looking at what entheogenic means. This is a case of the non-commercial use of a Schedule I drug that is authorized for personal consumption in the District of Columbia. And this is not the case of a commercial transaction, a commercial use of the drug. And I think that at the base level, this board is empowered to answer those questions. And this board must answer those questions because under OAG's interpretation, there's no way that we can appeal the harm that we are currently experiencing, despite the fact that we are asserting First Amendment constitutional rights and relying on Supreme Court precedent. That cannot be the correct state of the law in the District of Columbia. We look forward to your ruling on as to whether or not you have jurisdiction, and we are ready to move forward today with the factual determination that we will see the Supreme Court law does support what's going to come out of the facts, that this enforcement action cannot stand.
I guess Marley, you don't have any witnesses, so basically you're gonna try to prove your case. So with the government presenting and you cross-examine the witnesses, is that what you're saying to me?
Absolutely.
Okay. All right.
Chairperson, before you go to executive session, could we get an estimated time that you're going to come back just so we can take a comfort break?
It's 11:54. How much break are you requesting, ma'am?
A 5-minute break.
All right, with 11:54, we'll come back on the record at say 12:05.
Okay.
And if we need to extend it, we will let you know. All right, so
Thank you.
so we're off the record. No, we're not off the record. Hold on. No, you Miss Hogan Miller, you're trying to confuse me. So let me you I was just about to commit something that is just to get the board in trouble. So just hold on 1 minute. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with DC Official Code Section 2575 of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 25 ULC 00042, Temple of the Golden Teacher, pursuant to DC Official Code Section 2575B4A of the Open Meetings Act, and deliberating upon case number 25 ULC 00042, Temple of the Golden Teacher, for the reasons cited in DC Official Code Section 2-575B13 of the Open Meetings Act. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. I will now take a roll call vote on the motion before us now that it's been seconded. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. As the motion has passed, I hereby give notice that ABC Board will recess its proceeding to hold a closed meeting pursuant to Section 2-575 of the Open Meetings Act. All right, so it is 11:56. We're off the record until 12:10. So you just put your. I'll ask all board members to go into executive session, and all the rest of the parties just mute your phone and stop your camera, please. Okay, so we'll go into executive session till at least 12:10. All right, thank you. We're back in the record. All right, the board went into executive session to consult with our attorney regarding the novel legal issue that we were faced with this morning to address. And so this is the motion that I will, based on the board's our executive session conference with our attorney regarding the legal issue. I'm going to call for a vote to deny the motion for the following reasons. The board is bound to enforce Chapter 16B and cannot stop enforcement on its own based on federal law. The appropriate forum for these claims is a court of appeals or other court remedy. 2, in addition, whether the sale was commercial or non-commercial or non-religious is a question of a material fact that can only be adduced at trial. So the motion is to dismiss your motion at this juncture for us to move forward. And if depending on the decision that's made today, at least we'll develop a record for the court of competent jurisdiction to make this determination. So with that said, I make a motion that we dismiss the motion that's filed. Is there a second?
Ryan Jones, I second the motion.
Mr. Jones, the second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree with the motion.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter has passed 5-0. So we will move forward with the hearing to develop a record that if either party wants to, based on the decision that are made today, that if either party wants to appeal, or all decisions of the board can be appealed at the Court of Appeals. So where are we now? We'll start with the government.
Chairperson Anderson, the government is ready to present its opening statement.
All right, and just how many witnesses is it that the government currently has?
The government has 3 witnesses.
3 witnesses, and Mr. Brafer, you stated that you don't have any witnesses. Is that correct, sir?
No, Mr. Chair.
All right. The reason I'm asking, as you know, we're still in the morning and we still have another hearing and a protest hearing this afternoon. So at least and the board must take a lunch break. So I just for planning purposes that I'm asking. All right, fine. Go ahead, Ms. Hogan-Miller.
Ms. Laws will be presenting the opening statement.
I apologize. Go ahead, Ms. Laws.
No worries. Good morning, Chairperson Anderson. Good morning, members of the board. We're here today because Temple of the Golden Teacher was operating an unlicensed business that sold psilocybin mushrooms. And this is a Schedule I substance under DC law, and they were selling this to the public. The establishment may describe itself as a church, but the evidence will show that the actual setup and operations looked and functioned like a commercial establishment. You'll hear from MPD investigators who visited the commercial establishment. They'll describe display cases full of product, a stockroom, and a register full of cash. You'll also see photos and evidence seized from the premises, including mushrooms, edibles, and capsules, packaged, labeled, and priced for sale. You will also hear that customers were required to agree to membership rules before buying. These included disclaimers about law enforcement and the illegality of psilocybin. And the business's website and social media also promoted products and docent advice, not scripture or religious teachings. The board is not being asked to rule on the First Amendment. What before you is a question of licensing and public safety. Under DC Code Section 7-1671.08 G1, the board may summarily close any unlicensed establishment that sells Schedule I substances and presents an imminent danger to the public. And an imminent danger is defined as an establishment that's unlicensed and is selling Schedule I substances. And here we will show by substantial evidence that that danger is likely to occur if this establishment were to reopen. You'll hear from ABCA's supervisory investigator, Jason Peru, and MPD investigators Roberson and Ferrufino Lopez. They'll describe the pre-buy investigation and undercover buys that confirmed that psilocybin was being sold directly to the public. And at the end of this hearing, the district will ask the board to uphold and continue the summary closure of the establishment because the evidence will show that this was not a place of worship, but an unlicensed retailer of illegal substances, and that the risk to the public safety remains.
Thank you. Mr. Braithwaite, do you wish to make an opening statement or you defer until you present your case, sir?
Preliminarily, I'll say this. The district has assumed all of the facts. They have assumed that this is a commercial transaction. They have assumed that this cannot be a temple. They have assumed that there is no religion. They have assumed that there is no nonprofit operating. They have assumed that there is not a religious entity or a religious purpose for the possession and use of the sacrament. And they've assumed that Initiative 81 would not provide a safe harbor for the non-commercial distribution and possession of psilocybin. Those assumptions are all wrong. They are contrary to DC law. They're contrary to First Amendment law. After my cross-examination of the district's witnesses, what this board will understand is that the actions of the board, and not the board, but the police officers are subject to strict scrutiny. That means they're presumptively unconstitutional. So while I hear that the board believes that the application of Supreme Court precedent, but you didn't go as far as saying that the application of Supreme Court precedent is inapplicable here. But the essence of which is that under the law of the land, we're entitled to an exemption. We are non-commercial. We are within the statute, and the statute should confirm the authority of this board to approve or disapprove of the District of Columbia's enforcement action here today. With that, I will address you again at the close of the case. Thank you.
Thank you, sir. All right, who is the first witness?
The government would like to call MPD investigator Trevor Roberson.
Mr. Roberson, can you come on camera, please?
Morning.
All right. Can you raise your right hand, sir? Do you swear or affirm to tell the truth and nothing but the truth?
I do.
All right, your witness.
Good afternoon. Could you please spell and state your name for the record?
It's Trevor Roberson, TRAVOR
And where do you work?
Metropolitan Police Department.
And could I refer to the Metropolitan Police Department as MPD?
Correct.
What is your position with MPD?
I am an investigator with the Narcotics Enforcement Unit.
How long have you been an investigator?
I don't know the exact dates, but it's been a couple of years.
And what are your duties and responsibilities as an investigator with the Narcotics Enforcement Unit?
We investigate the sale of illegal narcotics within the city, within the District of Columbia.
Turning to the case today, are you familiar with the establishment located at 511 Florida Avenue Northwest, Washington, D.C., known as the Temple of the Golden Teacher?
Yes.
How are you familiar with this establishment?
I am the applicant on the search warrant for this establishment.
So before we get to the search warrant, did the Narcotics Enforcement Unit do an undercover buy at this location?
Yes, we did.
And what date did you do that by?
The first buy was June 24th.
And what date was the second buy?
Second buy was July 14th.
And were you the person who did the undercover buy?
No, ma'am. I'm on the arrest team.
And what does it mean to be on the arrest team?
So when we are doing these controlled buys, we do send the undercovers in a lot of times unsafe places. So just for safety, we do have members of the arrest team nearby in case anything goes wrong.
And so when these undercover buys were happening, where were you in location to the establishment?
I was within a 2-block radius.
And did you speak with the undercover officer who did these 2 buys?
Yes.
When did you speak with this undercover officer?
Once everything has concluded and we got back to our building.
And so let's talk about the first buy. What did the undercover officer observe inside the establishment?
Objection, calls for speculation.
It doesn't call for speculation because I asked, what did the undercover officer observe?
How would one person have the perspective of another such that I can tell you what somebody else observed? That exactly calls for speculation.
Investigator Roberson testified that he spoke with the undercover officer.
Speaking and observation, Mr. Chair, if you'll allow me further, speaking and observation are two different things. I think that if we want to know what the impressions of the undercover purchaser was, you could ask that of the undercover purchaser. To ask somebody else what somebody else saw, I'm not sure how that goes.
Administrative forms allow for hearsay testimony.
I was gonna rule to overrule the objection on the basis that this is an administrative hearing, and yes, we do comply with the rules of evidence, but not as formalistic as we do in court. So, for the purposes, I'm going to overrule the objection.
Thank you. I'm going to repeat the question. What did the undercover officer observe inside the establishment?
When he entered the establishment, he noticed there was somebody behind the counter, and to the right there was a glass case filled with products.
Objection, Your Honor. How is this not duplicative of testimony we intend to hear from the future from the person that actually observed it? Why are we hearing from this officer what that officer saw when the person is actually available? What's the relevance of this person's testimony on this point as to something they have not seen, not observed, and not experienced?
Ms. Hogan-Miller.
The government is not calling the undercover officer as a witness. And so Investigator Roberson's testimony is necessary to discuss the undercover buy that happened at the establishment.
I'm going to have a motion here with respect to not calling the undercover that actually participated in the control buy. And this is not obviously about Investigator Roberson, but that person has very critical information for this factual determination. That is the only person that interacted with the staff. The conversations therein are very important to determining what happened during the process. And the District of Columbia is in control of all their witnesses. If they intended to put on a case without the person that actually experienced it, it would seem that there should be some leeway given by way of my ability that I can't question that person to determine, or this court will not be able to determine what actually happened. In fact, this person is too crucial to be on the sideline somewhere for undisclosed reason and not participating in this hearing here today. As a matter of fact, they're the most critical linchpin of anything that exists today.
I can't tell the government what witnesses they can or can call. Again, this is an administrative hearing. We do not strictly abide by the rules of evidence. So I'm going to rule the objection. You can preserve your objection for the record moving forward, sir. All right, so I'm overruling the objection.
Thank you. Investigator Roberson, were you finished with your answer about what the undercover observed inside the establishment?
Yes.
Okay. So what happened once the undercover went inside the establishment?
Once he entered the establishment, he was met by an individual who worked there, and he inquired about the purchase of mushrooms. As he inquired about the purchase of mushrooms, the individual asked, "Are you a member?" To which the undercover officer declined. He said, "No, I'm not." Once he said that he was not a member of the establishment, the employee directed him to a QR code to sign up to become a member. Once he signed up to become a member of the establishment, that's when the conversation proceeded further about the purchase of the mushrooms.
Okay, let's talk about this membership. Did the undercover have to use an ID to sign up for membership?
No, he just signed up via the QR code.
Did the undercover receive a membership card after he signed up?
No, he did not get a membership card.
Did he receive anything for his membership?
He said he did receive, I'm not quite sure, I don't know how to explain this, but you know when you go to certain establishments where if you come this many times, you get this stamp and maybe the ninth purchase is free. He received something like that, as to that nature.
So what did the undercover?
If I may, this kind of goes to the critical point about the absence of this complaining witness. Here we have the officer placed in the impossible position of telling you what the person received, and he has no clue if he's even telling you the truth or not. He does not even know if this thing that he received, the quality of it, he does not know if it was an email, he doesn't know if it was a text, he doesn't know, and he's in an impossible position of telling you what he did not experience. I would again object, and this is kind of even straining credulity now that he's testifying to things he has no knowledge of, and then trying to tell you what someone received. So I'll either move to strike his answer as non-responsive because he lacks the information necessary to convey it to you, or again, it's a different way of asserting my objection that it's very impossible for Officer Robeson to talk about what he does not know about.
All right, I'm going to overrule the objection. I mean, the government can incorporate this through the evidence, and your objection for the record is noted, sir.
Thank you.
What did the undercover officer purchase at the establishment?
Mushrooms,
And how much?
3.5 grams.
How much did the mushrooms cost?
The mushrooms for the first purchase were $40.
And what about the second purchase?
The second purchase was $35.
Did the employee direct the undercover to donate to the establishment?
The first visit was described as if you would like to make a donation to the establishment, and obviously the donation would be the amount of the product.
Was there anything different at the second buy?
It wasn't discussed.
Did the undercover receive any instructions on how to consume the mushrooms?
No.
Was the undercover asked about their religious beliefs?
No.
Was the undercover asked about any of their medical conditions?
No, he was not.
What did the undercover do once they received the mushrooms?
Said goodbye and exited the building.
What happened with the mushrooms after that?
Once the mushrooms were purchased and he exited the building, we brought it back here to the office to do a field test.
And did anything else happen during the second undercover buy?
Just the same thing pretty much happened during the second undercover buy. He went in, he made the purchase, he asked, well, differently this time he went in the establishment. He was asked the same question, are you a member? To which this time, yes, because he signed up after the first visit. Once he went ahead and validated that the undercover was a member, then they proceeded with the purchase of the mushrooms. And as before, once the purchase was made, the undercover exited the establishment, came back to the office to field test the product.
So you talked about field tests. What is a field test?
A lot of times when we are making these purchases in the streets, in these establishments, a lot of these individuals could be selling stuff that looks like drugs or looks like Schedule I substances, and it's not. So we always make sure we field test it to make sure it does come back positive to what they're saying that it is.
Do you have any training related to field tests?
Yes, we do go. MPD offers the field tests, the training for field testing a lot of these narcotics that we come through on a day-to-day basis.
Would you recognize a photo of the product purchase at the establishment on June 24, 2025 and the field test applied to it?
Yes.
Okay, I'm now showing what's been marked as Government's Exhibit A2. Can you see my screen?
Yes, I can.
And let me zoom in. Do you recognize this photo?
Yes.
What is this photo showing?
This is the narcotics purchased by the undercover, the mushrooms.
And what is next to the what is depicted here on the right-hand side?
The field test.
And is this a true and accurate depiction of the field test conducted on the purchased mushrooms?
Yes.
And how do you know, and what is this field test testing for?
Psilocybin.
How do you know if the product test is positive for psilocybin?
When it tests positive, it'll kick back a slight color of the product.
And if it's negative, will it turn a different color?
You won't have any type of reaction.
And so what is this field test indicating?
Positive for psilocybin.
And where the picture, is the picture field test applied to the product that's in the picture?
Yes.
Chairperson, the district would like to note for the record that Government's Exhibit A, the case report for Temple of the Golden Teacher, and exhibits are already evidence pursuant to 22C DCMR Section 9715.10.
So noted. Because
If
of
I
the
may,
board. Yes,
Mr.
go ahead,
Chair,
sir.
OAG informed me that I had no right to discovery, so I have not received anything in this case besides the report. It would seem to be best prepared to cross-examine that I would need access to the evidence that OAG has intends to present today. At a substantial disadvantage by OAG claim that I'm not entitled to discovery despite the fact that I served the discovery request upon them.
We're saying two different things. I mean, she's moving in evidence, our documents that's already part of the case report. That's
And
already part of, yeah, go ahead, sir.
I don't have access to those documents.
So you didn't get a copy of the case report?
The case summary report, but these pictures and if there's other things like this, I've never seen these things.
Because the documents are a part of the case report, which is already in the record, so I'm going to overrule your objection and allow to move the document into evidence because it is part of our internal records. And so,
Mr. Chair, all I'm asking is, might I receive a copy of your internal record? That's it. Like, would you give me the courtesy of giving me access to what they have as a matter of fairness so that I can litigate this case the way I must litigate this case?
I guess I'll ask because I mean, what documents you're talking? All right, normally but again, because these are summary action, like in a normal show cause hearing, the documents must be exchanged 7 days before the hearing. In summary suspension hearings, because these are expedited hearings, I am not aware that there is any formal timeline for the exchange of documents. So I'm at a disservice right now to do that. But yes, I guess the bottom line is that at what point are you asking for these documents? Are you saying that you need them now or
Yes. If I may have access to them now, at least I could at least try to get more prepared. If OAG has documents and they've had it for 2 weeks, I asked for 2 weeks to allow us OAG and the licensee or at least the people that own the establishment to interact. There was no interaction, not at my behest, but at OAG's behest. Now they are able to present evidence to which I have no idea what they're going to present, the pictures and all that stuff. There's no harm or prejudice to me receiving photos and everything that's in that document. I request that this board order, as a matter of fundamental fairness and equity, that me as counsel for the respondent is entitled to the same documents that they're going to put forth before this very board.
Is there a problem with providing with a copy of the documents that I'm asking Ms. Hogan-Miller?
I was just going to say, as you said, Chairperson Anderson, that because these are expedited hearings, there's no disclosure deadline.
I know, but are you able to provide him with a copy of the documents while
I can do that once we finish with this witness.
Is that fine, sir?
It'll have to be, Mr. Chair, but you obviously understand the fundamental disadvantage with which I'm performing, and I appreciate that. And I'll appreciate some time to read through those documents that I may be better prepared before I move into cross-examination of the witness.
Well, I think part of the bottom line is that there's a summary action motion. You requested a hearing because the statute states that we have to provide a hearing within a period of time. The parties could could agree that this matter didn't have to be expedited. But so you requested the hearing. And so what was the basis of you requesting the hearing? I mean, I guess, and we have to, based on the statute, we have to provide the hearing date based on what the statute states. So I mean, you are aware that once you request a hearing, it's an expedited. So I don't understand behind the scenes why is it that the parties are not talking
It is
to.
not on me. It is not. I'm the one that had to send a gentle reminder, like, "Hey, I've had made this request 7 days ago without response," prompting them, and then 2 days later they responded saying that they didn't. Saying what they said that I won't refer to. But again, I would just say that it doesn't have to be this way. As a matter of fundamental fairness, the accused should have some right to be able to defend themselves and put forth the best defense possible. Here I am today. I am prepared to move forward with information I had. If it's just pictures, why wouldn't they share it and supposed to hold on to this insipid idea that I'm not entitled to anything to be able to represent my client?
I guess can I ask the government to send him a copy of the documents currently? I mean, and I think, Mr. Braithwaite, you could have requested a continuance because in order to accommodate the statute, we had to make sure that we had this hearing today because we meet on Wednesdays. So we had to make sure that we have this hearing, offer you the right to the hearing within the timelines. And so you, however, could have requested a continuance if you believe that you need more time to get the documents. But I'll ask the government to
Thank you.
just email your copy of the copy of the documents that are in the record.
The request was made of the government 2 weeks ago.
Chairperson, my co-counsel will email them.
All right.
We can
Thank you.
move on to the next question.
Okay. Go ahead. All right. Okay.
Board's indulgence. I'm now showing you what's been marked as Government's Exhibit N. Do you recognize this photo?
Yes.
Oh, do you need me to zoom in? Just let me know.
Yeah, a little bit. Yep.
What is this photo depicting?
This is the second purchase of the mushrooms that the undercover officer made.
Was a field test applied to this purchase?
Yes,
And what is the result of the field test?
positive for psilocybin.
Yeah, thank you. And is this a true and accurate depiction of the field test that was applied to the purchased product?
Yes,
At this time, the government moves to admit Government's Exhibit N into evidence.
You have an objection, Mr. Braithwaite, do you?
No objection that this is what they say it is.
Okay. All right. So again, this is the document is a part of the board's record, so I'm going to move it into evidence. All right.
Now turning to Government's Exhibit O, do you recognize this document?
yes.
And what's in this photo?
These are the mushrooms that are inside the Mylar bag.
And is this a true and accurate depiction of the purchased mushrooms?
Yes,
At this time, we'd like to move Government's Exhibit O into evidence.
All right. I'm going to move into evidence.
I'm going to stop sharing. Have you visited or have you gone to the establishment since the undercover buy?
yes.
When did you go to the establishment?
After the second undercover buy, we visited the establishment again on July 17th
And why did you visit the establishment on July 17th?
for the execution of the search warrant.
And what do you see when you arrived at the establishment on July 17th?
When we entered the establishment, there was an individual behind the counter directly in front of us. Because when you enter the establishment, directly in front of you is somebody behind the counter, and to the right, there's a glass case with all the products inside of it, with the cash register directly like on the left side of that case if you're facing it.
What happened once you entered the establishment?
And when we do these search warrants, the first thing we do have to do, just for safety, is to clear the entire building. So everybody inside the building, secure them, while the rest of the officers or investigators clear the building to assure that everybody's safe and everything's good to go.
And then what happens after you secure the building?
Once we secure the building, we ID the individuals, verify that they are who they say they are, and then we go ahead and go through the products that are inside the establishment.
And was anything seized that day?
Yes, we seized mushrooms, U.S. currency, and I believe marijuana.
How much money was seized?
From the establishment, $4,866, and on person of the individual was $1,290.
You said that the MPD seized mushrooms. Did MPD test the seized products?
Yeah, everything has to be tested. Again, when we do these search warrants or we do these interdictions within the city, we test everything.
Did the products test positive for psilocybin?
Yes.
I'm now going to show you what's been marked as Government's Exhibit J. Do you recognize this photo?
Yes.
And what is shown in this photo?
The mushroom products seized from the establishment.
And is this a true and accurate depiction of the mushroom products that were seized?
Yes.
I'm now going to show you what's been marked as Government's Exhibit K. What is being shown in Exhibit K?
These looks like the edibles, and then the pills within inside the establishment.
Lastly, I'm showing you what's been marked as Government's Exhibit L. Do you recognize this photo?
Yes.
And what's depicted in Exhibit L?
These are the mushroom pills.
And
Sorry, look this. Yeah.
were the products in Exhibit J, K, and L seized?
Yes.
And are Exhibits J through L a true and accurate depiction of the products MPD seized from the establishment?
Yes.
At this time, the government would like to move Exhibits J, K, and L into evidence.
No objection.
So move.
And what was the amount of products that were seized at the establishment?
Now, I don't know the exact amount when it comes to weights and grams of the products. If you could refer to the Gerstein, I could refresh my memory, but I don't want to give you an incorrect answer.
Okay, I'm going to turn to Government's Exhibit P. Do you recognize this document?
Yes.
And what is it?
This is the Gerstein for the search warrant.
And I'm going to the second page. Does this list the amount of products that were seized?
Yes.
And how much of each product was seized?
The marijuana, 3.5 grams. The mushrooms, 584.26 grams. The edibles, 618.1 grams. And then the pills is going to be 4,670.6 grams with packaging.
Thank you. I have no further questions.
Cross-examination.
Officer, you're an MPD officer, correct?
Investigator.
Investigator. And as an investigator, where are you currently assigned?
The Narcotics Enforcement Unit.
And you were selected for that by MPD, correct?
Correct.
And you are involved with the operation for the Temple of the Golden Teacher, correct?
Yes, I was.
Are you a DRE, a drug recognition expert for MPD?
Am I a drug recognition expert?
Yes.
I'm not a witness expert. That's
So
what you're referring to.
you are aware that there's MPD training to become a DRE, correct?
I'm not a DRE, if that's what you're asking.
Okay, so you're not a DRE, and so you've never completed the DRE certification program for MPD, correct?
I completed the narcotics unit training for this.
Okay, and so are you DEI certified by MPD?
I believe I just answered that question.
No, I asked you a different question. I said, are you DUI certified by MPD?
DUI?
Yes.
Objection,
no.
relevance?
Again, I'm just asking about his experience with MPD and drugs. You've put him in front here as an investigator of drug matters in District of Columbia. The relevance is these are ways that MPD has to recognize drugs, Your Honor.
I'm gonna overrule the objection. If the witness can answer the question, can answer the question if he can. If not, we move on. So answer the question, sir, if you can.
I am not DUI certified.
Okay. And have you been trained to detect impairment caused by psilocybin mushrooms?
I am not trained to do the impairment for psilocybin mushrooms.
And what about other entheogenic substances?
Could you explain theogenic substances, please?
Entheogenic is, I'll read it from Merriam-Webster to help your understanding.
Objection,
It is-
relevance.
Where are we going with this, sir? I'm just asking. Just tell me where are we going with this line of questioning?
Oh, well, basically, I'm going to connect the officer's knowledge and understanding and training to what the case is about today. And entheogenics are the matters that are currently before this board. And we would like to have a discussion with the MPD investigator on the narcotics unit that closes down entheogenic establishments about entheogens.
I don't.
If you allow me a brief leeway, Mr. Chair.
All right, I'll give you some leeway, but I'm trying to see how is this relevant to this case. So I'll give you some leeway, sir. And Ms. Hogamiller, you can raise objection moving forward, but I'm going to give him some leeway to see where we're going here. Okay, go ahead, sir. You can answer the question, Mr. Robeson, if you can.
He was still explaining the definition to me.
All right.
So entheogenic is, from Merriam-Webster, a psychoactive hallucinogenic substance or preparation such as psilocybin or ayahuasca, especially when derived from plants or fungi and used in religious, spiritual, or ritualistic contexts.
Okay, so can you repeat the question, please?
What training have you had to detect impairment by entheogenic substances?
So to answer the previous question, I am not DUI certified.
Okay. And what briefings that you had on MPD before beginning this operation, specifically on psilocybin?
Specifically on psilocybin?
Yes, sir.
We had multiple briefings on this establishment, but specifically—
No, that's not my question, sir. I'm sorry.
Specifically on psilocybin,
yes, sir.
We did not have any briefings.
Okay, and what about the religious use of psilocybin? Have you as an MPD investigator been briefed on the religious use of psilocybin?
I'm going to sustain. I don't think this witness has not been presented as an expert on the religious use of any drug. So I'm not quite sure where we're going with this specific witness on whether or not the drugs can be used for religious or non-religious purpose. I mean, I don't see how that's relevant to at least to this case.
Okay. If I may, you're aware that the temple of, let's get right to it then. Are you aware that the entity that was operating the establishment is a nonprofit religious organization?
Objection.
What's the nature of your objection?
First, the relevance of whether it operates as a nonprofit is not relevant. But second, it also calls for a legal conclusion about whether the nonprofit status or its religious status should provide it a drug exemption.
Well, I don't think that's not the question that's been asked. I think he's just been asked, is he aware that this is? I mean, I think so. I think I'm going to overrule the objection. He can answer the question. Let's see where maybe your objection is relevant moving forward, but I think that he can answer the question because it's a yes or no. So I'm going to overrule the objection, sir.
Are you aware?
Yeah, go ahead.
Are you aware that the corporation that runs it, that runs as a nonprofit religious organization?
I was aware that they were operating as a church.
Okay. And are you aware of Initiative 81 under the DC Code?
Objection.
Could
what's the nature of your objection?
The same, the relevance of Initiative 81 and that it calls for a legal conclusion.
Why is this, sir? Wow, I
Mr. Chair,
yes, sir.
I'm claiming that Initiative 81 provides a safe harbor for the operation of this particular church temple in the District of Columbia. They are claiming that there's no exemptions possible under DC law. You're at the end of the day going to be, your vote is going to come down to whether or not this board believes that there can be a religious exemption under the law.
I mean, the decision whether or not this is a religious entity or there is a exemption, that is not a decision that the board is willing to make. I'll just say that that is not our call. I don't know what that's not the board is not going to make a decision on whether or not there's an exemption for religious.
Well, you are going to make a decision by your rule. If you rule that there is no exemption, then there's only one way that you're going to come back on these facts.
I don't believe the board is going to rule on the exemption itself, sir. I don't
I understand.
Yeah.
But allow me, allow me, because this goes to the fact that he's narcotics enforcement. They're going after entheogens, and MPD is testifying. He understood. He just said he admits that it was a church. He understands it was operating as a church, but he also has some very specific beliefs and observations about this particular transaction that he believes it's a commercial entity. So I'm allowed to get into that to separate from fact whether it's in fact a religious transaction or non-religious transaction.
But what is I guess I'm curious how one can determine if a transaction.
Well, Mr. Chair, that kind of goes to my point.
Chairperson Anderson, may I respond?
Yes.
Based on opposing counsel's argument just now, he's seeking to have a legal conclusion that Initiative 81 exempts religious organizations from psilocybin enforcement. And that is not a legal conclusion that is appropriate for Investigator Roberson, but it's said with the board.
Again, this board can't make that decision absent the facts. So if the fact is the officer observed it to be, he says, I know it was operating as a church. That was his exact testimony.
All right. I'll allow the question. If you can answer the question, yes. If not, let's move on.
Thank you. So were you briefed on Initiative 81 prior to becoming a narcotics enforcement officer for the District of Columbia?
No.
Are you aware of Initiative 81?
Could you explain it to me?
No. As you sit here today, if I say Initiative 81 to you, anything comes to mind?
No, sir.
Thank you. And have you been instructed on how to assess public safety risk for the use of psilocybin?
Objection. Again, it calls for a legal conclusion that this board should make about the imminent danger or question.
No, the imminent danger requires facts, Your Honor. I'm asking them to state their facts on the record. The officer has to be able to explain the reason for this investigation, why this was an imminent danger to public safety. He must be able to explain this. Otherwise, how are we going to know that there was an imminent danger to public safety?
He's asking for the officer's legal opinion about whether there was
No, I'm not.
imminent danger to the public health and safety.
No, I'm not. And you're getting ahead of yourself.
All right.
And further, imminent danger is defined by the statute.
And I'm arguing that there are conflicting statutes. So, Your Honor, this case is boiling down to a question of law.
All right, I'm going to sustain the objection. Let's move on. Okay.
Investigator Roberson, are you still there?
I mean, we're waiting for the investigator. What I need you to do, Mr. Berth, you can ask the witness about his factual knowledge. All right, his factual knowledge. You can ask that question. All right, let's find out what's going on with the witness.
I messaged him that we can't see him anymore.
Okay, and he's not responsive.
I believe he just communicated that his phone died in the chat.
He doesn't have a charger, and I see it's in his car. He doesn't have a charger in his car to
I
charge
believe
his
he's
phone.
using another officer's phone. They're trying to get him online. He's seeking permission to be admitted.
Oh, there he is.
Okay, all right. Thank you. All right. Okay, hold on.
Can you see me?
Yes, sir. All
I
right, go
apologize.
ahead.
My phone overheated. It just completely shut off.
Okay, all right. Okay, go ahead.
Thank you for your time, Officer Investigator Robeson. So you've previously stated that you understood that the temple described itself as a church of some sort.
Right.
Okay, and you're further aware that the sacrament was the psilocybin mushrooms, based on their website, correct?
Can you explain the sacrament?
Okay. You reviewed their website, correct?
I did look at the website.
Okay, so you are the officer that initiated the search warrant, the arrest and search warrants, correct?
Yeah, correct.
Okay, so at no point in your investigation did you go look at the Temple of the Golden Teacher's website?
I didn't navigate the website.
Okay. Do you know if the person that's not going to be testifying today, do you know if they ever went to the website?
Repeat that.
There's an officer, the undercover officer that made the purchases. He's not going to be testifying today, correct?
Correct.
Did he ever discuss reviewing the website with you?
No, my question was about the word sacrament. Are you referring to the narcotics that were sold? Is that what you're referring to as sacrament? That was
That's
my
what I'm asking
confusion.
you. I'm asking you, was the psilocybin mushroom the sacrament for that church?
Was that what was being sold? I'm trying to. Can you elaborate that question?
All right, hold on 1 minute, please. What's it? There's an objection. So, what's the objection? I think there's some clarification. There's discussion going back and forth between the attorney and the witness regarding clarification. So you're raising an objection, ma'am, regarding what?
Regarding opposing counsel wanting Investigator Roberson to define how the church views its own religious practices.
Well, I don't think. I think the bottom line that the what was going on, clarification was being asked. So let's. All right. What was the question that was being asked initially?
Well, we're trying to connect the mushrooms to being the sacrament of the church, but the officer said he didn't review the website. So without the officer reviewing the website, now I'm trying to see if there's additional means and knowledge that he has by which he could testify as to whether he knew or not whether these mushrooms that he is seizing are connected to the operations of the church.
But I think, Mr. Burt, I mean, if you had a witness, I mean, you could call a witness to state
that's not the objection before the board.
But I'm just saying is that you could call a witness, and your witness could state what it is.
And that's neither that's the standard that the court above is going to look at either. The court above is going to look at the actions of the District of Columbia, and it does not look to the actions of the church. It looks to the actions of the District of Columbia, and I'm trying to ascertain factually from this officer what he knew or what the District of Columbia knew prior to executing an arrest warrant. He is the officer with the arrest warrant.
All right, I'm gonna overrule the objection. If the witness can answer the question, answer the question. If not, let's move on.
So, sir, do you know if mushrooms were used or distributed from this temple of the Golden Teacher?
Mushrooms were distributed to the undercover officer from, was sold to the undercover officer from this establishment.
Okay. And in your opinion, that's the same as any other illegal dispensary in DC, correct?
The sale of illegal narcotics.
I don't know. I'm asking you the question that I asked was, and that is the same as any other illegal drug dispensary in DC, correct?
Selling of illegal narcotics is, I'm not saying it's just every establishment is the same, but it's illegal to sell mushrooms in the District of Columbia.
And would you agree that you padlocked the doors that day?
I did not personally.
Were you on scene when the doors were padlocked?
I was not.
Okay. Do you know if the doors were padlocked?
They should have been padlocked. I was not there and I can't witness to that.
And you have already testified that mushrooms were seized that day, correct?
Correct.
Now, since you have expertise in the narcotics unit, would you agree that 3.5 grams of marijuana seized on the scene that day is clearly personal use marijuana?
Objection.
All right. I'm going to sustain the objection. I don't see how he can testify to that, sir. How can he testify whether or not it's that if you see 3 point?
Withdrawn.
All right.
Question withdrawn. Sir, do you know if it's legal to possess 3.5 grams of marijuana in Washington, D.C.?
Yes. You can have that on your person.
Do you know where that marijuana was located in the facility that day?
Do not.
And so it's your testimony today that you have no training on anything related to religious freedom and how churches can exist in the District of Columbia using Schedule I drugs?
Correct.
What facts do you rely upon to state that this facility posed an imminent risk to public health?
Objection.
What's the nature of your objection, ma'am?
Again, it calls for a legal conclusion. It was ABCA that issued the notice of summary closure. And so ABCA determined that this establishment presented an imminent danger to the public health and safety based on the fact that they were distributing Schedule I drugs in violation of the statute, by definition, is an imminent danger. And it's not appropriate to have this police officer discuss that legal conclusion.
That is not at all. From my perspective, it's this. If this was a simple assault case and the officer witnessed somebody striking somebody, I can ask the officer, and how do you believe a simple assault was committed that day before your very eyes? I'm asking the officer to link the facts, which is within his knowledge that he's actually experienced, into imminent risk to public health. I'm asking that he explain to us what he saw so that we could understand what his facts are.
But that's not the question you're asking him. So you're asking him to say, did he conclude this was imminent danger? So I'm going to sustain
Well,
the objection.
but it's important that you ask that. If you guys are allowed, if he was allowed to testify as to what the other guy thought, why can't I ask him as to his impression of what he saw that day?
But it's not relevant because he's not the one who made the decision, sir. He's not the one who made the decision. He went
has
out,
the
did it.
facts. I'm asking him what facts does he have. I must be able to inquire into his factual basis for his
But that's
opinion.
not the question that you have asked him, sir. So I'm sustaining the objection. Let's move on.
What is the factual basis for your opinion? Actually, I'll ask this way.
I'm sorry. Hold on a minute, please. All right. I'm hearing noise in the background, and I see Investigator Robinson. I see you're moving around, so I need you to be in a stationary position, sir.
Fire alarm went off. Apologize.
Oh,
then in the future, just tell us that what's going on. We'll take a break to get you where you need to be, sir. Okay. All right.
I'm here.
Thank you. All right. Go ahead.
And thank you, Investigator Robinson. I understand that this could be a little bit tense at times, but we're just trying to get your truths and your facts. So would it be accurate that there were no reports of any harm caused to individuals before the raid?
Objection, relevance.
It goes exactly to imminent risk to public health. I'm asking facts that would support that conclusion.
Imminent danger is defined by the statute. One of the definitions is that there's a distribution of Schedule I drugs. And so whether there are other complaints is not relevant to whether the board finds the fact that this establishment was distributing Schedule I drugs and that the danger would continue if it was allowed to reopen.
All right. I'm going to sustain the objection.
Okay.
All right.
So was a written warning issued before closure?
The warnings do not come from me.
Okay, so no, to your knowledge, sir, do you know?
I can't answer to that. The warnings do not come from me.
Okay. Did you have any discretion in determining how to respond to the information you received after the officer made those two purchases in July?
Objection,
Only one
relevance.
purchase was made in July.
Only one purchase was made in July.
All right. The witness answered the question. Investigator Robinson, if an objection is raised, please do not answer a
Yeah,
question
that was my
until.
fault.
Okay. All right. Let's move on.
Okay. And you would agree that there was never any interaction, to your knowledge, between the Metropolitan Police Department and this establishment before padlocking and seizing the mushrooms?
There have been calls of service to this establishment prior to that, but not through our unit.
Now, I previously asked you about that. What calls of service did you experience?
I do not interact with them.
Okay, I'm sorry. You said there were calls to service to this establishment. That's changing your testimony from earlier on, because earlier on, I asked you about what issues did you guys experience with this temple? What calls to service are you now talking about? And is that in the discovery plan?
Objection. Asked and answered.
It's not asked and answered. Clearly, this is a new question, and it's a new line of inquiry. This officer, for the first time, changes his testimony and said there were calls for service to this establishment prior to the execution of the arrest warrant. That's relevant.
And he also testified that he does not know, so it's beyond his knowledge.
But he also didn't go into the place, and he's been allowed to testify as to an interaction that he did not experience.
All right. All right. I'm going to stand the objection. If the witness can answer the question, he can give an answer or yes or no. Let's move on. So, are you able to answer the question, sir?
No.
So you have no facts that there were calls for service to this establishment prior to you executing the arrest warrant.
Objection, misstating his testimony.
I'm asking him the question to clarify the facts, ma'am.
All right. I'm overruling the objection. If the witness can answer the question. Let's move on. Can you answer the question, sir?
Is it your testimony today that there were calls for service to this establishment, to the Metropolitan Police Department, prior to you executing the arrest warrant?
I personally did not respond to those calls, so I can't give you that answer. So no.
Your answer assumes calls. I'm asking you, did calls exist?
Objection, asked and answered.
Sustained. The answer to the question, sir. Let's move on.
And would you agree that after a place is padlocked, that means that they can no longer continue operations?
I would assume so.
Okay. Are you aware that non-commercial ethnogen use is the lowest priority for MPD law enforcement?
Objection.
I always ask in order to help me make my
relevance.
Yes, ma'am. Go ahead. Yes, sir. Why is this relevant?
It's relevant because here we are for non-commercial ethnogen use, which is allegedly the lowest priority voted upon by the voters of District of Columbia, codified into DC law. So we have a statute that we are relying upon.
And this officer also can't speak for the whole department.
You just had to
It's
speak for the whole
enforcement
department.
use.
All right, okay. I'm sustaining the objection. Let's move on.
Would you agree that the distribution of mushrooms is only to individuals over the age of 21?
Objection, relevance.
I'm going to sustain the objection. I really don't know why that's relevant here.
Well, one of the criteria for risk to imminent public dangers if the psilocybin was being diverted to underage individuals.
But
So
I don't know.
that's
But
the
I'm not sure why you're asking this of this. This is not the witness who made those determinations. So this is not the person to call. So
He is the one. Sir, how old was the officer that you sent in that day to make the purchases?
Objection.
Sustained. The age is not relevant because you were not charged to selling. You are not charged with selling or serving this substance to an underage.
Will we stipulate then? Would I get a stipulation from OAG that there was no service of psilocybin mushrooms to underage individuals?
No.
I mean, no. What is it? You said no to what? To know that you agreed to him or? But that's not an issue. That's not an issue here. So I don't even know why we're even going here. There's no issue that the substance was sold or given to an underage. So I don't understand why this is even relevant. The age of the individual is not relevant because that's not that is not here, and whether it is not relevant. So let's move on.
Okay, so there were no hard drugs in the temple, correct?
Objection.
I sustain. I don't know what do you mean by hard drugs. So let's.
What about firearms, officer? Were there firearms recovered?
No firearms.
Did you observe any cannabis sales?
The only sales that I can speak of is the ones that we referred to earlier in this testimony.
Okay, and do you agree that from your knowledge given to you by the undercover that would not appear, that the purchase was restricted to members only?
Yes.
Would you agree that the undercover agent was over the age of 21?
Objection.
Would you agree?
Let's move on. Go ahead.
So, would you agree that being a member is not being a member of the public, general public?
Objection calls for a legal conclusion.
Sustain.
Do you agree that persons, the general public would include persons under the age of 18, for example?
Objection, relevance.
Sustain.
And so would you agree that in order for your officer to receive the mushrooms that day, he had to become a member?
Yes.
And it's still correct that MPD has given you no training on religious organizations that use Schedule I drugs?
Objection has to be answered.
Sustain.
And you would agree that but for the sale and use of the Schedule I drug, the Temple of the Golden Teacher would not have been padlocked?
Objection calls for a legal conclusion.
Sustained.
Mr. Chair.
That's not his call, sir. He did not make the decision.
Okay, Investigator, but for the presence of psilocybin in the mushrooms that you seized, would you have sought a warrant?
Objection relevance.
What do you mean by probable cause for a warrant is irrelevant in a case where he seeks a warrant and gets a warrant based on the fact that it was a Schedule 1 drug? It cannot be that counsel is now rejecting perfunctory for any reason, and it's not even based in the case. This is a case about psilocybin drugs. If he found no psilocybin drugs, why would he seek an arrest warrant? So, but for the psilocybin in the controlled buys, there would be no arrest warrant. That's a factual question.
I thought that. Well, I'm not thinking. I'm sustaining the objection.
No further questions.
Any questions by any board members? Any redirect, Ms. Hogan Miller?
Yes. Investigator Roberson, you talked about MPD training. What do they teach you about field tests during this training?
When it comes to the field
Beyond the scope of direct cross-examination, I never asked about field testing for psilocybin.
You did ask about his training.
No, I never. You're asking specifically about a question that was never brought up on cross-examination. It's just bolstering direct examination testimony.
I'm gonna overrule the objection.
Oh, so
The
what
witness
did you
can
learn
answer the
during
question there.
what did you learn during your MPD training about field tests?
Again, as I previously stated, a lot of times when we are making these illegal sales, I'm sorry, not us, but the sales of the illegal narcotics are being sold. A lot of times the illicit drugs or fermented drugs are not what they seem to be. So once we go ahead and get these drugs, we put it in the field test to make sure that it is what it says it is. And once it does test positive, it will pop that positive color of that illegal narcotics.
When the employee or when the undercover officer purchased the mushrooms, did the employee ask about their religious beliefs?
Asked and answered.
Sustain. Move on.
Investigator Roberson, when you were inside the establishment, what did you see?
Objection beyond the scope of direct. I'm not sure what this question is pertaining to. There's already established on direct examination, and none of these questions further the information that the board does not currently have.
And I'm not sure. I thought the witness stated that he did not go inside the establishment because he's not the one who did the buy.
He went in the establishment to execute the warrant, and he testified that when he came in, he saw certain things to the right and certain things to the left, and he had to clear the building. So at this point, this has been asked and answered.
All right. Sustain. Let's move on.
I have no further questions.
All right. Investigator Robertson, because I look at the screen, I see another name.
Yeah,
So
I apologize. Yeah, I had to
so
run and grab the phone.
so that's why I have to stop to figure out who exactly was speaking. Thank you very much for your testimony.
Yes, well, I'm gonna go ahead and take this
Thank you,
phone back
officer.
to whoever
And would you be
belongs
able to give the phone to Investigator Farafina Lopez?
to. I'm running over there right now.
happened? Oh, they're asking. Hello?
Hold on 1 minute, please, ma'am. Does the government have another witness?
Yes, the district would like to call Investigator Ferrafina Lopez.
Investigator Ferrafina Lopez, can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Your witness, ma'am.
Could you please spell and state your name for the record?
I'm Investigator Ferrafina Lopez. First name Yesis, Yesis. Last name Ferrufino, Ferrufino hyphen Lopez, Lopez.
Where do you work?
At the Metropolitan Police Department.
What is your position with MPD?
I'm sorry?
What's your position with MPD?
I'm an investigator.
And what unit are you an investigator with?
I'm assigned to the Narcotics Enforcement Unit.
How long have you been an investigator?
Less than 2 years.
What are your duties and responsibilities as an investigator with the Narcotics Enforcement Unit?
As an investigator, we have to investigate drug complaints by either utilizing an undercover officer or confidential informants, and based on the results that we get on those operations, I'm able to apply for a search warrant, author a search warrant, and also conduct by bus in different locations.
Thank you. Let's turn to the case today. Are you familiar with the establishment located at 511 Florida Avenue Northwest, Washington, D.C., known as the Temple of the Golden Teacher?
Yes.
How are you familiar with this establishment?
A drug complaint was made that they were selling illegal products without a license.
And did you go to that location?
I did a few days before just to check the area, to see where it was located.
And a few days before what?
It was like before we conducted a undercover buy.
And what location was this establishment in?
At 511 Florida.
And what kind of building was it?
Well, from the outside, it just looked like a regular building, like a house or something. Hat pink building.
And after you went there the first time, did you ever go back to the establishment?
I did.
And why did you go back to the establishment?
That's when we had to respond to execute the search warrant that my coworker had applied for it.
And did you go inside the establishment?
Yes, I did.
What did you see inside the establishment?
The first thing when I went in, I could see a desk right in front of me, with a person sitting on that side. To the right side, it was like a glass case full of items for sale. And as I started moving to the back, I could see like different like little rooms and a closet where we found product.
Do you take photos inside the establishment?
I did.
Okay, I'm going to show you what's been marked as Government's Exhibit B. And let me know if at any time you need me to zoom in. Do you
Okay.
recognize this photo?
Yes.
And what is this photo showing?
It's showing the product that is being sold at the location.
And in relation to the front door of this location, where is this located?
511 Florida Avenue.
But when you go into the door,
Oh.
where would you find this?
It's
what's in this
once
photo?
you walked in into the businesses, it's to my right.
And what was inside the display cases here?
It was mushrooms and mushrooms edibles.
Now turning to Government's Exhibit C. Do you recognize this photo?
I do.
And what is shown in Exhibit C?
That they had a deal, like take two peekaboo gummies for $70.
And where did you find this sign?
It was on top of the glass case.
That we
Like
saw in, was it what we saw in Exhibit B?
yes.
Now turning to Exhibit D. What is Exhibit D showing?
That's the cash register right on the glass case.
And did MPD find money in the cash register?
Yes.
Showing you what's been marked as Exhibit E. What's Exhibit E showing?
That's the desk that you see the moment you walk into the establishment.
Now I'm showing you what's been marked as Government's Exhibit F. Do you recognize this photo?
I do.
And what part of the establishment is this photo showing?
It's like in the back. It's one of the back rooms.
I'm going to show you what's been marked as Government is Exhibit G. Do you recognize this photo?
Yes.
Where was this in the establishment?
Still back in in the back room. It was multiple rooms in there, like yeah, it was like kind of like close to the where the desk was.
Okay. And lastly, I'm showing you what's been marked as Government's Exhibit H. Do you recognize this photo?
I do.
And what is this photo showing?
That's the closet where all the product was locked in.
Mm-hmm.
The mushroom product.
Are the photos in Exhibits B through H a true and accurate depiction of the establishment on the day of the seizure?
Yes.
At this time, the government would like to move Exhibits B, C, D, E, F, G, and H into evidence.
No objection.
So moved.
I have no further questions. Thank you.
Cross-examination.
Officer, you said that you received the complaint prior to going into the establishment. Who made that complaint to you?
Well, not specifically to me, but the officials. They
Who are
they
the
get
officials?
my sergeants.
Objection.
Who are your sergeants?
Are you asking for specific names?
Objection.
Somebody-
Relevance and outside the scope.
I'm sorry, what was the question? I'm
I'm
sorry.
asking her who reported to her. She said she received complaints. I'm asking where did she get the complaints from? I'm asking for the name of the
Well,
individual.
I know it is.
She can answer
I
the
know it
question.
is.
All right, hold on. Okay, I'm going to overrule the objection. She said complaints, so okay, she can answer the question to the best of her knowledge. Go ahead, ma'am.
Okay, so I know it's a complaint. The sergeants, they receive it. The sergeants ordered me to actually go and check on the location. He told me it was a complaint that we were gonna be conducting an undercover bite, and that's what I did.
How many
That's
sergeants
the
do you
reason I
have,
responded
ma'am?
to the location.
I'm sorry, who's speaking? I'm sorry.
How many sergeants do you have?
Objection.
I'm sorry.
Okay, hold on 1 minute, please. Remember, there's a court reporter trying to keep. All right, so I only can have one person speaking at a time. All right. Did you have an objection, ma'am?
Yes, the relevance of how many sergeants she has.
Because I'm asking her for the name of a sergeant and she keeps on passive voice, people unknown. If they are members of the police department that made a report to her, she know or she should know who they are. I'm just asking. She said sergeants. Are several sergeants
Well, yeah,
making
because
complaints?
I do have
Hold on, ma'am. It's the attorney speaking. Just
I'm
hold on.
sorry. I'm sorry.
Hold on.
I'm sorry.
Yeah, hold on, please. Okay, go ahead, ma'am. Sir, what were you saying?
So I'm just asking, inquiring of the officer to the factual basis of the reason that she was there.
Sergeant is
But
here.
wait, investigator, wait till we decide
Oh.
on the objections. Thank you.
Oh, I'm sorry.
Yeah.
And what was your objection, ma'am?
The relevance of who her sergeants are doesn't matter. And it's also outside the scope of direct.
I'm not limited to the scope of direct.
Why are you not limited to the scope? It's not your witness. You're cross-examining a witness. So yes, you are limited to the scope of direct. Okay, but I'm going to sustain the objection. But you're limited. You're cross-examining a witness, so you're limited to the scope. It's not your witness. You're limited to the scope of what was called indirect. But for other reasons, I'm sustaining the objection. Let's move on.
Okay. So when did you receive the report?
I don't remember the exact
Objection.
date.
All right, ma'am. All right. If there is an objection, that answers the question. So let's move on. All right. So let's move on.
Okay. Are you back?
Yes, the light went off. That's why.
Thank you. Okay. So the nature of the complaint you received was from your sergeants?
Yes,
Several or one?
one sergeant ordered me to respond to the location.
Okay. And and what investigation did you complete before going into the establishment?
Objection outside the scope of direct.
The factual basis of a police officer's actions are always within the scope of cross-examination.
All right. I'm going to overrule the objection. If she can answer the question, she can answer the question. Can you answer the question, ma'am?
As I said previously, I responded to the location to take a look at the business to where it was located and took photos.
What else did you do that day?
That day, it was just that.
What if anything, did you conclude from looking at the building?
Like I said, I just went to take photos to look at the business to where it was located. I never went inside. I never was like right there, right in front of the building. No, I just went, took pictures, look at the location, and that was it.
And did you ever go to the website?
No, I did not.
Let's move on. Okay.
Okay. Did you know that they were a church?
Objection.
I don't.
All right, ma'am. If there's an objection, no answer. But all right, she's answered the question. Let's move on.
Was your answer no, ma'am?
I say I don't know.
And after that first day you scoped out the joint, did you ever go back into it besides the serve and the search warrant?
I went on the search warrant.
Okay. Do you have any information about anything with respect to this case between the time you went in the initial and the service of the search warrant?
Objection.
What's the nature of your objection, ma'am?
First, it's outside the scope. She testified about what the inside of the establishment looked like and the relevance to her investigation. We had Investigator Roberson testify about the investigation.
All right.
That's not an objection. That's not an objection. It's not even based in rules of evidence, not based in law. It's just an objection for the sake of being an objection. And I'm not. I keep getting interrupted with these these objections, but there has to have a tight nexus to what I'm asking. I'm asking to make sure that I'm done with the witness, that there's no factual information she has in between the two instances she's been to the
All
scene.
right. I'll overrule the objection so we can get as much facts as, I mean, within reason. So if you're trying to establish fact pattern for appeal, but I think we need to make sure that we ask the relevant question that is going to assist the board in making a determination. Okay.
Thank you. So, officer, you have no other facts, or what facts do you have about this establishment? Did you get any facts in between you first going and you serving a search warrant?
What exactly, like, are you asking me, like?
What do you
Rephrase
know?
the question, sir. She doesn't understand the question.
So you were not a part of the investigation of the this particular temple.
When I was when I don't even remember. I don't remember.
Thank you.
I don't remember.
Ma'am, you said you don't remember, so let's
Yeah.
stop. Go ahead, let's move on.
No further questions.
Any questions by any board member? Any redirect?
Nothing from the government.
Investigator Farfina Lopez, thank you very much for your testimony. Have a great day.
Thank you.
Does the government have another witness?
Yes, we have one additional witness. We'd like to call Investigator Jason Peru.
Mr. Peru, can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Your witness.
Thank you. Could you please state and spell your name for the record?
Jason Peru, Jasonperu.
And where do you work?
For the District of Columbia Alcoholic Beverage and Cannabis Administration.
And what is your position there?
Supervisory investigator in charge of cannabis enforcement.
And could you explain your duties as a supervisor investigator?
Conduct inspection and investigations of licensed cannabis facilities and unlicensed retailers.
Okay. And how long have you been involved in this line of work?
I've been with ABCA for 12 years. I've been doing enforcement for the past year and a half of unlicensed facilities, been involved with medical cannabis programs since 2020.
All right. And in your cannabis enforcement work, have you come across other establishments selling controlled substances?
Objection.
What's the nature of your objection?
The nature of my objection is how is that relevant to this specific instance? Basically, if we accept the fact that he has worked with ABRA, he has worked at ABCA for a significant period of time, stayed in over 12 years. Of course, he has been to other facilities, but are we going to detail all the facilities he's been to? I don't understand how is this relevant to the case before us today.
I'm going to overrule the objection. I mean, that I believe that I don't know Mr. Peru, so well, let me not say in this particular case, I don't know Mr. Peru. So Mr. Peru is providing us some information, providing the board with information. So I'm going to overrule the objection.
So I'll re-ask the question. In your line of cannabis enforcement work, have you come across establishments selling other substances?
Yes, I have.
And what kind of substances? Just some of those substances that you've encountered.
We've come across cocaine, amphetamines, opioids, magic mushrooms containing psilocybin, quite a long list of different things.
All right. So you mentioned psilocybin. Is that a Schedule I substance?
It is.
And is it allowable in DC for retail establishments to sell controlled substances?
Objection calls for a legal conclusion, as OAJ reminds me.
I'm going to overrule the objection. I believe it's a question that Mr. Peru should be able to answer.
Can you repeat the question, please?
Sure. Is it permissible for retail establishments in a district to possess, sell, or distribute Schedule I substances?
It is not.
All right. And are you familiar with Initiative 81?
I am.
So what is Initiative 81?
Initiative 81 is a law that was passed in DC that allowed for essentially personal possession of mushrooms for personal use and made it a low priority for criminal enforcement from the police department.
All right. And does Initiative 81 make it legal for a retail establishment to sell or distribute psilocybin?
Objection.
What's the nature of your objection, sir?
It calls for a legal conclusion and potentially the ultimate conclusion.
It says, I'm going to overrule the objection. He's talking about whether or not for a retail establishment, can they sell? I mean, I'm going to overrule the objection. All right.
I have not seen anywhere in I-81 that allows for the commercial sales of psilocybin mushrooms.
All right. So let's turn our attention to today's case. Are you familiar with the establishment what is it called? Golden Temple of the Golden Teacher located at 511 Florida Avenue Northwest?
I am.
All right. And what kind of establishment is Temple of the Golden Teacher?
An unlicensed retailer selling
It was a
psilocybin
lot of
mushrooms.
objection.
I'm sorry. I'm sorry. I'm Mr. Oriana, can you please?
But I would say,
Hold on,
he would say, push
Mr.
him off,
Oriana.
like,
Mr. Oriana, can you please?
Apologies.
Okay.
All right.
Okay. Go ahead.
So I was asking, I'll repeat the question. What type of establishment is Temple of the Golden Teacher?
An unlicensed magic mushroom retailer.
All right, so you mentioned that this is a retailer. In your investigations, do you ever review the certificate of occupancy for businesses?
I do my research into the business.
So did you review the certificate of occupancy for this business?
I did through DLCP's website.
Okay, just gonna share my screen.
Yeah.
Are you able to?
I'm sorry. No, Mr. Oriana, can you allow Ms. Wilson the ability to share her screen?
Access has been granted.
Go ahead, ma'am.
Okay, I'm now showing what's been marked as government exhibit I. Okay. Can you please tell us what this document is?
Can you zoom in a little bit, please? A little bit blurry, just so I'm making sure it's just the one that I looked at. Yes, it's the C of O from 511 Florida Avenue Northwest.
Okay, and does the address on the C of O match the address for the establishment, Temple of the Golden Teacher?
It does.
And could you tell us what the approved building code, the approved zoning code for the establishment is?
The zoning code says retail establishment, general use retail.
All right, and okay, you answered my second question. Okay, so at this time, I would like to move government's exhibit I into evidence.
No objection.
Without objection.
Okay, I'll be sharing my screen again at some point. But so how did you become aware of this retail establishment?
I received an anonymous call saying that the former unlicensed cannabis retailer known as Verified had a new operator and was now selling mushrooms at this location.
So after you got this complaint, did you do an investigation?
Yep, I looked into the business.
And as a part of your investigation, did you look at the business's website?
I did.
And do you remember the date that you first accessed the website?
I have to reference my report to get that exact date.
Well, when you visited the website, did you take a screenshot of the website?
I included exhibits in my report, yes.
Okay. So I'm going to share my screen again. This is Exhibit A, which is already in evidence. So we're going to Exhibit A1. I'm going to zoom out. So are these screenshots an accurate depiction of the website on the day that you visited the website?
It is.
Okay. And can you tell us about what you saw on the website?
Pictures of mushrooms, descriptions of magic mushrooms, containing the words psilocybin, pictures of the inside, as you can see here, which appears to be a retail establishment.
And did you see any products for sale on the website?
There was products listed, yes.
Okay. And do you recall seeing this photo here?
I do.
Okay. Could you describe what we're seeing on the screen?
I mean, it says XXX premium magic mushroom capsules, advertising capsules, 300 milligram XXX, And it says it also contains ginkgo biloba, Korean ginseng, ashwagandha, and matcha to get you in the zone for love, play, and fun.
All right. And can you tell us what magic mushrooms are?
I guess it's the generic term for mushrooms that contain psilocybin that create a psychoactive effect.
And so based on your review of like looking through this website, was there a way for individuals to purchase products from the business?
You had to go into a different drop down menu to then lead you to a I believe it was a membership joining page or whatnot.
So now I'll present what's been marked as Government's Exhibit M. And does this look like a fair and accurate depiction of that membership page or the application that you were talking about?
Yeah, I saw it in the digital form. But yes, this is could you scroll down a little bit
Sure.
just so I can see that's what I saw.
Okay. Well, let's just quickly go through this. We'll start at the top. Could you read, it looks like there's some prompts for the membership, like this sentence here.
Do you sincerely believe and embrace the use of entheogenic plants such as mushrooms as part of your religious beliefs?
And what options does someone have to answer that question?
Yes or no?
Okay. And then let's just, I guess, go down to the rules for membership. I've highlighted 2 areas here. Would you mind reading those 2 areas?
Could you zoom in some? The yellow making it kind of hard to read.
Let me just move this over. Is that better?
Yes, perfect. Thank you.
Okay.
It says the top paragraph highlighted says, I consent that I am over the age of 21 or older, am not affiliated with or employed by law enforcement or any other government agency involved in law enforcement. In parentheses, it says, if I am a law enforcement officer, as a condition of my membership, I agree to identify myself with my badge number when at the temple, even if I am not verbally prompted or asked for such badge number.
All right. And could you read this second area that's been highlighted in the second paragraph, please?
I understand that psilocybin is viewed by law enforcement in many jurisdictions as a controlled substance and accept the risks of possession and consumption. I certify that I have thoroughly researched and educated myself about the potential risks, side effects, and long-term consequences associated with the sacrament and expressly and specifically accept and assume such hazards and risks, including any and all risk of injury, harm, loss, or death that I may incur as a result of my participation in the use of sacrament.
Great. Thank you. At this time, I'd like to move Government's Exhibit M into evidence.
No objection.
Without objection.
And now I'm just going to move back to the website that the screenshots that you took on the day that you visited the website. I'm going to zoom out. And so do you recognize this screenshot here?
I do, from their social media page, I believe.
Okay, so is this a true and accurate depiction of their Instagram page for the Temple of the Golden Teacher?
Yes, at the time it was.
Okay, and could you describe what's in this photo?
It says brain fuel, looks like appears to be mushroom capsules. And then if you read the description below, I think it references great ready to lift your microdosing game with brain fuel. And microdosing is known in the mushroom world of a way to take certain amounts that have different effects. So if you take the whole thing, you might have psychedelic effects. You take a little bit, you might have calming effects, and so on. So when I see the word microdosing, most times it is has been associated with magic mushrooms containing psilocybin.
Yeah, I'm just going to close this screen. So based on your investigation, and reviewing the website and the social media page, did you take any action?
I did. I work with the members of the MPD Narcotics Enforcement Unit to conduct controlled buys when I feel sometimes it's difficult to do a buy internally. And I gave them the information about my concern about this location selling psychedelic mushrooms.
And why were you concerned about this location selling mushrooms?
There's been several illegal mushroom shops in the District of Columbia selling mushrooms illegally without licenses. A lot of the unlicensed cannabis retailers were started selling magic mushrooms. The magic mushrooms are not regulated or tested by any lab to certify that they're in fact safe for use. Therefore, and according to DC statute, a unlicensed sale of a Schedule I substance is illegal at a retail level. Therefore, I proceeded with actions.
Right. And after you referred the case to MPD, did you remain involved in the investigation?
Yes.
Okay. And how did you remain involved?
In close communication with the MPD narcotics team of the day of the controlled buy, the results of the controlled buy, and what type of products were purchased.
So after you learned that there was this undercover buy, what did you do next?
I drafted the case report that you showed earlier and submitted it to the OAG for closure.
And so after you prepared your report, what did ABCA do at that point?
The report was sent to OAG, then it was came back with a summary closure signed. I waited for the Narcotics Enforcement Unit to have the assigned warrant, and then the closure and warrant was executed on the same day.
All right, no further questions.
Any cross?
Sure. Good afternoon. How's everything, sir?
Afternoon, sir. Good. How are you?
I wish I was meeting you under different circumstances, but
I'm sure we will at some point.
The question that I have for you is: have you been sitting in on this hearing the entire time before being elevated as a participant?
Yes, I was here.
So you were able to listen to the testimony of the other witnesses in this matter?
I caught some of it. Yes.
Okay. And you're not with MPD, correct?
Correct.
Okay, and with ABCA, what type of training does ABCA give around religious uses of Schedule I drugs in District of Columbia?
Objection.
What's the nature of the objection?
Relevance.
I'm gonna overrule the objection since the claim is being made that this is used for religion, and so I'll overrule the objection. If you can answer the question, you can. Or
Sorry, sir. You mind repeating that again?
Sure. What training have you received on the religious use of Schedule I drugs in District of Columbia?
I have not received training on religious use of drugs.
Okay. And you're familiar with Initiative 81?
I as much as I can be, yes.
Okay. And so you are aware that Initiative 81 recognizes that there is religious use of these entheogens for religious and ritual purposes and the like.
I'm aware that any religious use would have to be permitted and permissioned and licensed by the DEA. I'm aware of that.
But Initiative 81 authorizes personal use in the District of Columbia. Would you agree?
Personal use, correct. Personal possession and consumption, yes.
And the District of Columbia does not define that personal use and possession of these entheogens are public safety risk. Would you agree?
I have not seen those exact words tied to it, no.
May I be permitted to share my screen?
Mr. Ariana, can you allow Mr. Braithwaite to share his screen?
Access granted.
Thank you, sir.
Okay, brief indulgence. I'm now showing you DC Code 48921.5 5-1. Do you recognize this?
Give me a second to read it real quick.
Do I need to enlarge it, or how are you
No.
doing on vision?
No. It's clear.
Thank you, sir. And let me know when you're finished, because I have some questions based on this section of the DC code.
Okay, I have read it.
All right. So, and now actually for another part of my question, and I just want to get this out of the way. Are you familiar with what entheogens or entheogenic means?
I am.
Okay. So then you would agree, as Webster has it, a psychoactive hallucinogenic substance or preparation such as psilocybin or ayahuasca, especially when derived from plants or fungi and used for religious, spiritual, or ritualistic context. Would you agree?
Agree with that definition?
Yes.
Sure.
Okay. And you would agree that this section of the DC code refers to the entheogenic plant and fungus policy.
It does say that.
Okay. Would you agree that the DC code exempts non-commercial use of psilocybin in the District of Columbia?
Objection.
What's the basis of your objection?
He's asking for a legal conclusion. He just read the words here, and it says what it says.
I'm going to overrule the objection. He can answer the question if he can. Are you able to answer the question, Mr. Peru?
I'm able to see what he's highlighted there and what I've read previously. Yes, it says non-commercial.
So it says non-commercial planting, cultivating, purchasing, transporting, distributing, possessing, and engaging in practices with entheogenic plants and fungi. Would you agree, sir?
It says non-commercial, correct.
So do you believe that a religious use is a commercial use?
That I don't quite understand
Objection.
that question.
What's the nature of it?
The code speaks for itself.
The code does not speak for itself, otherwise we won't be here. We are asking if there is if there's a non-commercial use, would you agree that it is not a commercial use?
Was that the question?
That is not a question before the witness. Can he answer that question?
I believe there's commercial and there's non-commercial, and I believe.
Would you believe where would you believe religious use falls on that spectrum? Would you believe that will be under commercial or non-commercial?
I wouldn't have an opinion or a thought about that.
I'm asking.
All right, the witness has answered the question. What's the next? All right, what's the?
Okay.
Is there another question? I'm sorry.
Yes, brief indulgence. Would you agree that this Initiative 81 intends to allow for individuals to be able to have or possess ecobanya, dimethyltryptamine, which is DMT, mescaline, psilocybin, and psilocin.
Objection. This calls for a legal conclusion.
He can be aided by the code, Mr. Chair. He doesn't have to have an opinion. He just needs to be able to read the code. And he is the only person that came on the screen as a witness and says, I understand Initiative 81. I'm an expert.
He never said he was an expert, sir. So he was never qualified as an expert.
But I will argue that he's the only expert among us.
You had an opportunity to bring a witness who could have been an expert on Initiative 81. I think we should stick to what we're here to do. And
all right, so I'm going to sustain the objection. Let's move on.
Okay. But it's clear that the voters of District of Columbia voted to make this the law of the District of Columbia. Would you agree, sir?
Objection.
It's the nature of the objection.
He wasn't involved in the voting. This just goes beyond the scope of our direct.
Well, he stated. Hold on. All right. I'm going to sustain the objection. If the witness can answer, he said he was familiar with Image of 81. If he can answer the question, he can, and let's move on. Can you answer the question, Mr. Peru?
In reference to voting or how it was voted upon, I cannot.
Okay. So are you aware that this is the DC code? Would you agree with that statement that I'm presenting to you the District of Columbia code?
Yes.
Would you agree that the DC code is the law of the District of Columbia?
Yes.
Would you agree that you're here pursuant to the DC code to apply a DC code section in this prosecution and summary closure procedure?
Object. Objection.
I'm going to overrule the objection. He can answer the question if he can.
I'm confused by the question though. If you're asking me if I was enforcing 81, that's
No,
not.
sir. I asked, are you enforcing a DC code section here today?
Yes, there's a DC code section that we referenced. Correct.
And all the actions you have taken have been pursuant to the DC code, correct?
Correct.
Okay.
DC codes, yes.
And you would agree that I am displaying the DC code to you today, correct?
Yes.
Objection. Asked and answered.
Let's move on. All right. So I'll overrule the objection. Let's move on.
So you have actually visited the website, correct?
I have.
And is it clear that the Temple of the Golden Teacher is representing themselves as a church or religious organization?
The word church, I don't remember reading that exact language.
Okay. Would you agree that a temple is how they describe themselves?
Correct.
Would you agree that temple has a religious connotation?
Objection.
Let's just say objection.
Also, and temple can be your head. Like it doesn't mean it's a religion.
That's not even an objection. It's literally not even an objection.
All right. I'm gonna sustain the objection. I'm not quite sure where this is not for Mr. Peru. I think we have a better time for Mr. Peru. I don't think it is in Mr. Peru's his expertise to say what a church is or what a temple is. I mean, that's not all right.
Then allow me. Mr. Peru, is it within your expertise to determine what a church or religion is in the District of Columbia?
No, not my expertise. No.
Thank you. And you have received no training on the Religious Freedoms Restoration Act, correct?
Training, no.
So do you have knowledge of the act?
I have read the act, yes.
All right. Yes, answer. Let's move on.
These objections are perfunctory and they don't have a basis in law or fact.
Sir,
Ask the individual.
We have a whole day. We're still in our morning calendar, and I still have the board has to take lunch, and I still have an afternoon calendar. So let's move on.
I do apologize. I do apologize. So you would agree that this temple was treated the same as any illegal dispensary in the District of Columbia?
As an unlicensed retailer, yes.
And you would agree that the doors were padlocked?
Yes, upon closing, correct. The
And
locks were changed.
And that psilocybin mushrooms were seized that day?
Yes.
You would also agree that the marijuana seized that day at 3.5 grams is of no moment to this case?
Objection.
What's the nature of your objection?
That calls for a legal conclusion. Did you say it's no moment? How is that Mr. Peru's his call here?
I'll withdraw. Mr. Peru, are you aware if possessing 3.5 grams of marijuana is illegal in the District of Columbia?
2 ounces or less. So.
And would you agree that 3.5 grams is less than 28 grams?
Yes.
Thank you. Would you agree that there was a membership protocol in place at this temple?
I did see the application, yes.
And would you agree that you have no knowledge of anyone being able to purchase psilocybin from the temple without first being a member of the temple?
Correct.
Do you know if within ABCA there's an opportunity for you to seek legal advice as you come across specific fact patterns in your investigations?
Yes, there's always availability to seek counsel.
And was counsel involved in any of your operations with respect to this temple?
I'm gonna
Objection. I don't, what's the relevance?
sustain. Move on.
Did you see any legal issue with closing this temple for the mushrooms distribution?
Objection. Calls for legal conclusion.
Sustained. I don't know whose phone is that, so can that person please silence their phone, please? Or whatever is making that noise, can it be silenced, please?
So there was never any interaction with the temple prior to closing, correct?
I did not have interaction.
Whoever has art, I don't, there's 3 lines that are, I think, open. It is not mine. I am asking that please silence whatever it is that's making that sound, please silence it.
Sure. Now, what connection does the Temple of the Golden Teacher have to the prior occupants of this building?
I'm sorry, can you say that again?
What connection does the Temple of the Golden Teacher have with the prior occupant in the building?
I have to object with relevance.
He testified that he received...
hold on, sir. I'm overruling the objection. Let's move on. He testified that we were informed that the agent was informed that the previous owner. So go ahead. Yeah.
So do you know if there's, in your investigation, have you uncovered any connection between the 2 entities?
I'm sorry, what entities are we referring to? I'm sorry.
I don't know. Who occupied the building previously?
Oh, you're asking if I found a connection between the 2. That's what you're asking me?
Yes, sir.
I do not know of any connection between the 2.
Okay. Are you aware if in that display case, as you call it, any of the packaging in the display case contained psilocybin?
I'm not aware.
Is there a license that can be sought in the District of Columbia for the distribution of psilocybin?
There's not.
Is there a testing facility that tests psilocybin in the District of Columbia, if you know?
Exclusively, no.
Do you know of any?
It can be tested, yes.
And okay. And do you know of any exemption for religious use of psilocybin in District of Columbia?
I'm not aware of anybody in District of Columbia that has a exemption for religious use.
Can you close your screen, please, sir?
Thank you. That concludes my questioning.
Any questions by the board members? Mr. Peru. I'm sorry, go ahead, Mr. Meadows.
Good afternoon. Inspector Peru, there's been a lot of discussion on DC Code 48-921.52. And I wanted to read because it has not been mentioned earlier. You were discussing the Metropolitan Police Department has made the investigation and arrest of persons, and then as among its lowest enforcement priorities. Do you understand that section of the code?
I think so.
Okay, and would you say that a enforcement priority could be high or low?
Correct.
And would you say that an enforcement is an action taken to uphold the law?
Yes.
Thank you. Thank you, Mr. Chairman.
Any other questions by any of the board members? I guess the question I want to ask, Mr. Peru, have you visited any other establishments within the district or legal establishment with a license in the district that are licensed by ABCA to sell cannabis or any other products, similar products?
Licensed cannabis retailers? Yes.
Yes, sir. And I guess what when you did you physically enter this establishment?
No, I was not there during the day of the closure.
No, I'm just saying, have you been into this establishment?
Prior, as the old business, yes. Not as the current.
But you have not been into this establishment. Is that correct?
Yes, correct.
Okay, I don't have any further questions. All right, Mr. Braithwaite, do you have any questions off the witness based specifically on the questions that were asked by the board?
I have no further questions.
Any redirect, Ms. Hogan Miller? I'm sorry, Miss Wilson, I apologize.
No further questions. The government rests our case.
Mr. Peru, thank you for your testimony. You're free to go.
Thank you.
All right, the government rests. Mr. Braithwaite, do you have any witnesses you wish to call, sir?
No, the district does not wish to call any witnesses. What we have submitted a motion, and to the motion attached were affidavits that are recognizable under DC law under the penalty of perjury about the practices available at this particular temple location. And we would like to either be able to submit to you in writing. Again, I think this is more of a question of law case as opposed to a question of fact case. And about and I think that the facts are as they have always been, but I think that the application of law to those facts is what merits further consideration.
Chairperson, may I respond?
Yes, ma'am.
As the board has denied the establishment's motion, the board should also not consider the affidavits that were attached to it. Further, the affidavits don't identify who this person is in relation to the temple, and if the temple wanted, they could, or the establishment wanted, they could have called its owner as a witness to be able to verify these affidavits. But without any witness to verify the contents of these affidavits or the affiant, the board should not consider that evidence.
If I may, Your Honor, I recall being a young prosecutor in DC Superior Court, and I had an affidavit from the Department of Transportation concerning someone's license. And a judge looked at me and says, well, how am I supposed to know that this person is who they say it is? This could be a janitor at the DMV signing these affidavits. And I would say to the court that here is what the rub is. The rub is that these affidavits signed under the penalty of perjury are recognized both under the United States Code and the DC Code as acceptable competent evidence. And it should be accepted into your evidentiary review because it provides for you the context that's currently missing. To the extent you wish to hold my client, penalize my client for not appearing today to give testimony, that certainly is within the board's ability. But I would suggest that the equity that's at play here, where I have had no discovery, despite requesting the same 2 weeks ago, I've not been able to prepare with the same record. I'm finding with one hand tied behind my back. And, you know, it is just, I think that the merits of this case require a closer look. And I think that if you allow us to brief the submission as opposed to just already argue it, I think that that best serves not only the interests of the District of Columbia, but it also best serves the interests of the Temple of the Golden Teacher, that this board may adjudicate on full facts and full argument that was given thought. None of the arguments that my colleague, Ms. Hogan Miller and Ms. Wilson advanced today are arguments that are based on paper with legal research to tell me that my Supreme Court precedent is not controlling, or to explain to you why the DC Code must not yield to the United States Supreme Court precedent about the First Amendment. These issues should be briefed. And I would ask for an opportunity to provide a briefing because this is not the simple run-of-the-mill enforcement action. And I think it requires a closer look and more scrutiny.
Unfortunately, Mr. Braithwaite, this is a summer action motion hearing. You requested this hearing. The statute states that we have to hold this hearing within a specific timeline, and we also have to issue a decision within a specific timeline. You could have requested, you could have asked for a continuance. You control this forum, sir. You could have requested a continuance to say that you needed, this is how much time you need to proper prepare for your case. So where we are, sir, we had to hold this hearing within the specific timeline, and we have to issue a decision. So within these timelines, I don't see how it is that I can consult our general counsel to see at what point, how much time do we have to issue our decision? And
I
so
believe it's 5 days, but I'm proposing a submission today to you. I suppose I want to get my submission, my points to you within an hour after I get off the screen. I don't expect, it's not going to be on me.
You can submit it. I will consult with our general counsel whether or not we can consider this information. That's all I can say. I cannot provide you an answer currently, but if you're saying that you're going to submit that, I will consult with our general counsel to see whether or not I can leave the record open. I'll provide an answer prior to whether or not I can leave the record open for additional submissions. Okay, sir? But I will provide an answer before the conclusion of this hearing.
Chairperson, if
Yes.
the board were to consider any written submission, the district would ask that we would have sufficient time to respond. And that the establishment would waive its 5-day order.
Waived.
Oh, as I said before, I'll find it from our general counsel what is it that the statute requires, and I will provide an answer prior to the conclusion of this case.
And please note that,
yes, sir.
I apologize, that we are willing to waive the 5 days. I think this requires serious consideration.
I'll provide an answer before the end of this hearing, before I officially close this hearing. All right, so I guess where we are, because the government has rested, you have also rested in the sense that do you need a couple of minutes to do closing, or where do we go? Where are we?
I do have a closing argument to put the final bow on it, but from my perspective, our case in chief is closed.
All right, fine. So you have rested, so it's time for closing. So does the government wish to do a closing argument?
Yes.
Go ahead, ma'am.
And before I do my closing, I would like to reserve time for rebuttal.
So that's fine. I'll give you a brief. It's 2:30 it's 2:30 and we're still in our morning calendar.
Yes,
I still
I
have
understand.
two additional summary hearings. We have already canceled one hearing, our protest hearing, and we have 2 summary suspension hearings that we must conclude today. Okay, go ahead, please.
May it please the board. This was a mushroom shop. Today, the government had to prove to you by substantial evidence that the establishment presented an imminent danger to the public health and safety because it was distributing Schedule I substances in violation of DC Code 7-1671.08G. We showed you that through the testimony of MPD investigator Trevor Roberson. He testified about the 2 undercover buys that happened at the establishment. During both buys, the undercover went inside, asked for mushrooms, paid for the mushrooms, and bought magic mushrooms. The undercover was able to walk out the store with those magic mushrooms without consuming them inside the store. Investigator Roberson testified about how the purchased mushrooms both tested positive for psilocybin. You also heard from ABCA investigator Jason Peru and about how he testified that establishments are not allowed to distribute Schedule I substances, including psilocybin, in this district. We asked the board to continue the summary closure of this establishment because the sale of Schedule I drugs is likely to continue if the establishment was to reopen and the board was to lift the summary closure. Let's look at the facts here. And all the facts you need to determine the summary closure are here in the record for you today. First, the photos. You saw it. That was a retail space, not a religious one. There was a large display case with multiple sections with different products in each display case. You saw a cash register, and that MPD investigator Roberson testified that they seized about $4,800 from the establishment. You saw a sign, a promotional sign, that said that people could buy 2 mushrooms for $70, a limited promotion. You saw a storage room from floor to ceiling with products organized. You also saw their certificate of occupancy that listed that it was a retail location. Now, turning to the rules of membership. If the board reads the rules of membership, it actually reads as a waiver of liability, similar to if you want to go kayaking or zip lining, promising that you will not sue the establishment. One line in it is, quote, "I'm executing this waiver of rights and release of liability as of today's date," quote, unquote. What does this all point to? That this is a commercial operation, not a religious one. Then we look at the amount of product that was seized at the store. In total, it was about over 5,800 grams of mushroom product that was there. This isn't a small amount for a congregation to use for personal use. This was the amount for a retail establishment. And you saw the types of products they had. Not only was it the mushrooms, it was gummies, it was chocolates, it was pills. This all again points to being commercial products that would entice the regular customer. Now, the argument here today is that somehow commercial activity and religious one cannot coexist together, that they're mutually exclusive. But look at a Christian bookstore. Yes, it is selling specific products for a specific religion, but that does not exempt it from sales tax and that it's and other regulatory operations because it's a religious establishment. But also, just because something is a church does not mean that the sales that happen inside it by definition are non-commercial. It's a factual inquiry. And the inquiry you have done today will show that this was a commercial space. And let's look about what we didn't see or what we didn't hear. They have provided no evidence to rebut what was presented today and show you that this was a religious entity. For example, there was no testimony about the fact that the mushrooms are only consumed in a ceremonial way, or that there is any ceremony about it. Investigator Roberson testified that the undercover didn't receive any instructions about how to take the mushrooms, or was the undercover required to take the mushrooms only inside the establishment? He walked right out. You didn't hear about the fact that people can receive these mushrooms, or sacraments if you call it, for free, that people have to give a donation. And that, again, when we look at the cannabis space, looks like a commercial transaction. There was no questions about the fact that people were screened for medical or mental health conditions. The undercover was not asked about their physical conditions. The undercover also did not have to provide ID. So there's no guarantee that people under 21 are not signing up for their membership. There's no rules about membership requirements. And everything else that they might point to is all factual evidence that they were not able to produce in this evidence or this hearing, and that if they had, they would have. If this place looks like a store, it acts like a store, and it is registered as a store, then it is a store. The religious argument is a red herring. That is why the government asks that you affirm the summary closure of this establishment and continue the summary closure because it presents an imminent danger. Thank you.
Thank you. Mr. Braithwaite.
Since before Jesus Christ, churches have been able to rely on its membership and the donations made thereby to subsist. The Catholic Church is one of the greatest landowners in the Americas. Hell, even in the District of Columbia, Georgetown University, they own a lot of land, and they are Jesuit, and they are a church. Churches and money have been together since Jesus Christ was overturning money pits in the temples for them conducting business on church property. Here we are, a church, a fledgling religion that needs funds to operate. The sacrament that people consume is not free. The sacrament that we wish to provide for people is not free. There's a cost to doing business. Now, when I say there's a cost to doing business, I'll alert you to, I'm from Trinidad and Tobago. My mom went to the Anglican church. And what the Anglican church in Trinidad and Tobago will do is if you were lined up to receive communion and you had not paid tithes and had made a donation to the church, they tapped you on the shoulder and said, not you, you're not in our book, you're not authorized, you're not okayed for communion. The fact that something is a religion, the fact that something is not a religion, is something that we need to look at closely. What we really don't want, we just want caution on the behalf of the District of Columbia. If they identify that something is potentially religious, we just want them to proceed cautiously. What you heard here is that the District of Columbia has woefully underfitted the people in charge of enforcing not only all sections of the DC Code, but specifically Initiative 81. They have not been prepared for anything that does not look like what they want it to look like. So regardless of what our temple looks like, regardless of how the sacrament is distributed, to them it was always going to be a duck. It was a duck from the first things. What did the officer, Inspector Peru said? He said the same establishment that was selling cannabis in here previously is now selling mushrooms. And he judged us not based on any action that the temple took, but based on what they believe to be the case. They did not judge us on our own processes. There is no suggestion that the membership, for example, was not adhered to, that it was some sort of sham membership. There's no suggestion that only OAG makes in closing, talking about underage people. Did you see the lengths to which I went to ensure that there was no knowledge with an MPD that there was any underage things? And then in their closing argument, they come back and be like, well, it could be diverted to underage kids. Those are not the facts. At the very start of this, OAG said that you didn't have jurisdiction to decide this question. That somehow these individuals hereby assembled on this board are not competent based on all of their years' experience to make a factual determination as to what the law requires of them. Well, the DC Code is law, but so is United States Supreme Court precedent. There's something called the Supremacy Clause of the United States Constitution, so that DC will argue that the RFRA, RFRA, does not apply to this proceeding. It's an interesting take on the law. I don't agree with it. And here's why I don't agree with it. The only way the District of Columbia acts is through its employees. The corporation itself, the municipal corporation, takes no action ever. It's only through the executive. And the executive must be subject to reasonable checks and balances. This board is assembled as a reasonable check on balance on the authority of the executive. What you will find in my briefing, and from the facts of this case that has been testified to by these witnesses that they put forth, the minute they heard Schedule 1, they shut down. While the Supreme Court themselves has allowed a church to not only import DMT, which is a Schedule 1 drug, without a DEA exemption, they ruled that it must be able to continue using Schedule 1 drugs. So the District of Columbia is sorely out of time where they've given personal exemptions. The same thing that's possessed by the individual in their hands is criminal in our hands. It's subject to this enforcement action in our hands without respect to any religious use. This case is a case of first impression. It allows this board to affirm that you do have jurisdiction. You do have jurisdiction over the question as to how does Initiative 81 interact with the rest of the DC Code. It is law like any other law, and it instructs the executive to make it the least priority. I wish this board will stand up for itself, assert jurisdiction, and determine what priority should this case be given? Is this the case that requires the most stringent application of the law in padlocking and not allowing them to conduct any activity? We've been padlocked since they summarily decided that we were selling a Schedule I sacrament, Schedule I mushrooms. We don't contest the evidence that MPD has or the characterizations that they place on it, because obviously from their perspective. But what I'll guarantee you is this: the facts testified here today prevent MPD from having any reasonable objection or facts to suggest that they did anything but did the most restrictive thing that they could do. They immediately padlocked the facility. There was no discussion. There was no investigation. There was no search and inquiry. It would have took them a week. It would have took them 2 weeks. And then when I asked for a 2-week period so that we could engage in discussions, 0 discussions occurred. ABCA's position remains today, as it always has been, that Schedule I drugs, they don't care if it's commercial or non-commercial, because they're not going that far. The employees that are charged with doing this, hardworking public servants, deserve better. They deserve advice on, well, how do we deal with a religious issue? Because what's happening right here is that even in the closing argument, OAG is talking about churches and it's asking you to prefer the presentation of a religion in one space, but not the next. It's actually asking you to decide what is and what is not a church. And what the Supreme Court precedent demands of you is that you don't look to the actions of the church. You look to the actions of the executive branch to see whether the executive branch violated the law. And the law is clear. MPD was supposed to take the least restrictive approach. People are already walking around with Schedule I drugs in their pocket in the District of Columbia. Lest we forget that marijuana is a Schedule I drug and federally illegal. So this alleged piety with no facts about crime, no facts about violence, no facts about overdose, no facts, no inquiry, no investigation. That is what they'd like you to say is substantial evidence to support the idea that MPD took the least restrictive approach to these operations. Because they say it's a business, it must be a business. But I asked Mr. Peru, I said, well, can they be registered to conduct business in DC? Any registration? There's no registration if you want to distribute mushrooms in the District of Columbia. There's none. So the fact that they are established as a retail establishment is of no moment, because that is the only legal slot hole that they fit into, because they're distributing the psilocybin. Now, they are asking you implicitly to okay one religion over the next, and I'll ask you to resist that. The very document that I'm going to attach, which is called Finding Zenlightenment, is on the website. It is described as our religious text. It is clear for all to see and understand what our beliefs are. And we don't believe like other religions do, that a man should stand in between you and your God. This entheogenic path is a path of personal enlightenment. It is getting rid of the intermediary. It is taking away those people that get in the relationship between man and God and allowing you to directly commune with the divine. The very God that this temple praises is a God called Soma. And Soma comes from the Hindu religion. And Soma is both the drink that they consume, that's entheogenic, and the deity herself. How is this any different from any other sacrament that people undergo at church for communion, whether it's wine? But because our wine has psilocybin in it, our sacrament contains psilocybin, they argued something is wrong with that. But if the Supreme Court said that DMT is okay for a sacrament, psilocybin is also okay for a sacrament. And because the District of Columbia took the most restrictive action, took no attempt to interface with the church, no attempt to conduct an investigation, No attempt to do anything beyond what they were trained to do, which is to catch people that sell drugs. And they want to convince you that we are people that sell drugs. No cocaine, no amphetamines, no firearms. The marijuana possession was definitely personal in nature. This was a non-commercial transaction. If you believe that it's religious, it's non-commercial. If you believe it was sold by a nonprofit, it's non-commercial. And with that, I ask you to come back with the only decision that makes sense. Look at the facts, look at the MPD training, look at MPD's actions. MPD was very happy with disrupting the operations of this church, and they were very successful in doing so. No sacrament has been able to be issued at that temple. And they think that this is the way MPD should interact with all religions in District of Columbia that believe in the partaking in this particular sacrament, despite the fact that there is not any other means to distribute psilocybin in the District of Columbia. The law cannot stand against the face of this unconstitutional action. It violates the free exercise clause of the United States Constitution, First Amendment. It violates RFRA. It violates DC Code section for the Initiative 81. Please, board, exercise your power today to say no. There has to be a different path. If the personal use is allowed, the non-commercial religious use is actually already allowed. If you say that the actions of this particular temple are congruent with DC Code Initiative 81, you don't need to make any further decisions. You don't have to go to the constitutional question, because then our actions will be legal. But if you find that our action is not exempted under Initiative 81, now you have to deal with the Constitution and the First Amendment. And that law squarely confirms that everything the District of Columbia did in this case was dead wrong. They are following the wrong rule book, and this is exactly the rule book that the United States Supreme Court has mandated that all governments play by, even the federal government, especially the federal government. This is the appropriate rule book. This is the law that controls. I ask you to come back with the only decision that you can, that in this case, as applied to these facts where MPD took no further investigation, even while acknowledging that it was a church and a temple, that is not what the law requires of them, and therefore their actions cannot be upheld. Thank you.
Thank you. You need to do a brief.
It'll be brief.
Yes, ma'am.
Board members, I'll start where opposing counsel started. The cost of doing business. That's what this is, a business. And that's what the evidence showed you today. And I'm not going to go over it because I already did in my closing argument. But let's go over what is not in evidence. There is nothing in evidence that this place is a church, a temple, that even the people or its owners practice this religion. Where was this evidence? There was not testimony. There was not exhibits submitted. The only thing you have heard so far from today is from opposing counsel. And his arguments today are not testimony. There's no evidence in the record that this place is any different than a non-religious establishment selling Schedule I drugs in a storefront. The evidence does not support that. The evidence supports that this place presents an imminent danger because it was selling Schedule I drugs, and that if it was allowed to reopen, it would continue to do that. Therefore, we ask the board affirm the summary closure and continue it. Thank you.
Thank you. All right. By statute, the board has 5 days to issue a decision. But as you know, Mr. Berther, the padlock will remain. So you're asking to do what I can style as conclusion conclusion of law facts, that you want to provide something in writing, which I can grant, but what is the timeline that you are requesting to provide for you to provide that to us. And the government is also asking for an opportunity to respond. So you can let us know what is your timeline, what timeline is the government requesting, and then we can figure out whether or not how much time I can grant, and whether or not you agree for us not to issue the decision within 5 business days from today.
I'll propose, because I do believe that the actual transcript will be greatly aiding the fact section of what
You're not gonna get the transcript for that
No,
because
I'm gonna.
the transcript would usually normally would take 3 weeks to. I'm just saying, in typical cases, like the transcript is usually available in 3 weeks, and I'll give you 30 days after you receive the transcript to provide the conclusion, the facts, and the conclusion of law. Which in this particular case, I don't think you'd want that because the establishment will remain closed during that period of time. So you're not going to have access to the transcript unless, if you want the transcript, you're talking about waiting 3 weeks or so to receive the transcript. So
No, well, I do believe, at least reviewing the factual testimony, we have several hours of factual testimony. While the memorandum of the law remains the same, the facts do significantly color the arguments here, especially going back and hearing what the officers had to testify to. I would suggest, if I be given 7 days, give the District of Columbia 14 days, and then 5 days after I'm able to do a reply, and then have the board the opportunity to review the case in a whole and come to a reasoned decision. I think that that's appropriate. We are willing to waive all timelines that the statute has on the board to allow you to have a considered opinion in this case, and not just rush you guys to any particular judgment one way or the other.
but you're aware that the business will remain padlocked during this period.
Well, it must remain padlocked because you guys haven't rendered a decision. But
Right, that's what I'm saying. So
rushing a decision benefits anyone.
All right, so you're saying, so what's the timeline are we agreeing to? So let me write this down. What is it? So you're asking for what timeline to provide a?
If I have 7 days, and then how much time does the District of Columbia need?
We request 14 days. Are you saying 7 days from today?
Yes.
Okay. Yeah, we request 14 days.
And if I can have 5 days for a reply?
All right, 7 days, hold on. So you're asking for 7 days from today to provide a closing. The district is asking for 14 days from when?
From the day they file their brief.
And the district is asking for 14 days from the day they reply. And then you're asking for an additional 5 days to do a reply. Is that what you're saying, sir?
Yes, Mr. Chair.
If the parties agree, if this is agreement for the parties, then fine. We can agree to that, knowing that the padlock will remain on the property during this period. So if the parties are agreed, I know that we will issue our decision. I will speak to our general counsel what his timeline, what the board's timeline to issue a decision, but we will issue our decision in as quickly as possible within the confines of the law. I know that we can go, the timelines could be waived for 90 days, but I don't think in this particular case the parties want to do that. So, but we will. So it's 7 days from today that the movement will provide their response. 14 days from their response, the government will provide its response, and then the movement will have another 5 days to reply, and then the board will issue a decision. I can't say how long we will take to issue the decision, but we will issue a decision as quickly as possible. But I just want to remind the parties that the padlocks will remain on this property until the board has issued the decision. So if the parties are in agreement, then that is the agreement that we've reached today. Okay.
Thank you, everyone.
All right, I need to close the case before but I just need to do that before I officially close the case. All right. All right. All right, as chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, in accordance with DC Official Code Section 2-575 of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 25 ULC 00042, Temple of the Golden Teacher, pursuant to DC Official Code Section 2-575B4A of the Open Meetings Act, and deliberating upon case number 25 ULC 00042, Temple of the Golden Teacher, for the reasons cited in DC Official Code Section 2-575B13 of the Open Meetings Act. Is there a second?
Ms. Quinn, I second.
Ms. Quinn is second. The motion will have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Jones, I agree.
Mr. Anderson, I agree. As the motion has passed, I hereby give notice that the ABC Board will recess its proceedings to hold a closed meeting pursuant to Section 2-575 of the Open Meetings Act. Thank you very much for your presentation today, and we will issue a decision. This is a case of first impression, and we will give it all the time and to make a reasonable determination. All right. Thank you very much. Have a great day.
Thank you, everyone.
All right. What I'm going to do right now is that I'm going to just close the record. I'm going to have for the board to have a lunch break, and so I'm not going to do the agendas until we come back. So let me just finish the the morning calendar. The next case in our morning calendar is case number 25 ULC 00052, which is J&D Market Super Grocery and Convenience Store, which is on trade name Supermarket. This case has been canceled. An offer in compromise has been provided to the board for its review and consideration. The next case on our calendar is case number 25 ULC 00054, Penn Smoke Shop. And this case has been canceled due to the submission of an offer in compromise for the board. So what the board is going to do is 253. We're going to, I'm going to ask the board, we're going to take, basically, let me advise the board members. We have for this afternoon, we have 2 additional summary suspension hearings that we must have today. All right, so we have continued the protest hearing. So the protest hearing will be continued, and so we have two summaries which are similar to the case that we just had. We'll have this afternoon. So it's 254. I'm going to ask that we're going to come back to the public hearing at 2:30. I'm sorry, it's 2:54. I don't know what I'm thinking about. At 3:30. So we're not going to go to executive. We're going to come 3:30. When we come back at 3:30, I'm going to do the agendas at 3:30. And then once the agendas are done, then we'll start our afternoon. We'll do the 2 afternoon hearings. So I believe that the parties for our 1:30, they should come back at 3:30. We probably won't start. It probably will take about 10 minutes or so to do the agendas, but that's the first thing that I will do this afternoon. So the board then is in recess until 3:30. I'll ask all board members to come back to hear the public session at 3:30. All right. Thank you very much. We're back on the record. All right. Good afternoon and welcome to the afternoon session of the ABC Board. My name is Donovan Anderson, chairperson of the board. Joining me this afternoon, at least for the beginning, are three other board members, Mr. Silas Grant, Ms. Terry Jean Quinn, Mr. David Meadows. The board has currently 4 members in attendance. 3 members actually constitute a quorum, so we do have a quorum to conduct business this afternoon. So let me go through the calendar that we have for this afternoon. Now, before we go over the calendar, I need to do our agenda items for this afternoon. And so the first agenda items that I will do this afternoon are the legal agenda alcohol. And the first matter on our legal agenda alcohol is review of a settlement agreement dated July 31st, 2025 by and between Advisory Neighborhood Commission 6D and Theater Alliance. The license number is 132943. I make a motion that we approve this agreement. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We have a I'm sorry. All right, I'm sorry. Hold on 1 minute, please. Mr. Jones, you're making my life very difficult this afternoon. All right, I'm sorry. Hold on. All right. Joining us this afternoon is Mr. Ryan Jones. He's the 5th member of the board. The board has 5 members in attendance this afternoon, and we do have a quorum. So as I stated before, the first matter that we did, that we need to vote on, it's a settlement agreement for the Theater Alliance of the Theater Alliance, license number 132943. If I remember correctly, Mr. Grant, did you second the motion? So Mr. Grant second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones. Mr. Jones, I can't hear you, sir.
Mr. Jones, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Number 2, review of a motion to dismiss Advisory Neighborhood Commission 6C. This is in Nando's. This is in case number 25 PRO 00025, license number 097889. I make a motion that we deny this request. Is there a second?
Quinn, I second.
Ms. Quinn, I second the motion. We have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Number 3, review of opposition to motion listed above. This is in case number 25 PRO 00025, license number 097889, Nando's Peri Peri. This is now moot. Number 4, review of reply to opposition listed above, dated August 7th, 2025. This is in case number 25 PRO 00025, license number 097889, Nando's Peri Peri. This is also moot. Number 5, review of motion to dismiss a group of 5 or more individuals. This is in case number 25 PRO 00075, B&B Convenience and More, license number 132583. I make a motion that we deny this request. Is there a second?
Mr. Meadows, I second.
Mr. Meadows, I second the motion. We have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. Number 6, review of motion for reinstatement. This is Mola Empanada, license number 123761. I'll make a motion that we approve this request. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones, I second the motion. We have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. Number 7, review of motion for reinstatement dated August 5th, 2025. This is Kitchen by Cocktails by Kevin Kelly, DC, license number 125989. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. Number 8, review of request to withdraw protest dated August 6, 2025. This is in case number 25 PRO 00045, trade license number 099229. I make a motion that we approve this request. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
And Mr. Anderson, I agree. The matter passes 5-0. All right, hold on, please. Let me. So let's move now to our legal agenda alcohol addendum. Number 1, review of an offer in compromise. This is for Angelo Bar and Grill. This is in case number 2525100007. The license number is 116070. And the offer in compromise is as follows. Charge 1, failed to ensure security camera were operational, first primary tier violation. Statutory authority, DC Code Section 25836G1. There is a $1,000 fine to be paid within 30 days, or the license shall be suspended indefinitely until the fine has been paid. And enforcement is to conduct a walkthrough to ensure security cameras are operational. I therefore make a motion that the offer in compromise be accepted. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. Now, we now move to our legal agenda, medical cannabis. The first matter on our legal agenda, medical cannabis, is review of public comment. This is for Proper Exotica. The license number is 128697. This is just an FYI for the board. Number 2, review of motion for reconsideration. This is for clinical health and wellness. This is in case number 24 PRO 00073. The license number is 130766. I make a motion that we deny this motion. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter pass 5-0. Number 3, review of motion for reconsideration. This is for DC Garden Hill LLC trade name. There's no trade name. This is in case number 24 PRO 00074, license number 128406. I make a motion that we deny this request. Is there a second?
Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter pass 5-0. Number 4, review of opposition to motion listed above. This is in DC Garden Hill. No trade name. This is in case number 24 PRO 00074. The license number is 128406. This is now moot. We now move to our legal agenda, medical cannabis addendum. The first matter on this agenda, it's a review of a motion to lift summary closure. This is in case number 25 ULC 00043 unlicensed. This is cap and stem. I make a motion that we approve this motion. Is there a second?
Mr. Meadows, I second the motion.
Mr. Meadows, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter pass 5-0. The next matter on the agenda is a review of an offer in compromise. This is in case number 25 ULC 00052. This is Super Convenience, JD. And the offer in compromise is as follows. The OIC terms as follows: products not to be offered, exchanged, or sold. Respondent confirms that it has ceased selling cannabis or cannabis products and agrees not to offer, exchange, or sell either in the store or online the following products: cannabis or cannabis-derived products, including all cannabinoids, hemp, CBD, tetrahydrocannabinol, otherwise known as THC-A and THC, kratom, and 3 any Schedule 1 substance, including psychedelic mushrooms and or dimethyltryptamine, otherwise known as DMT. Respondent agrees not to offer, exchange, or sell alcoholic beverages without an alcohol license issued by the ABC board. 2, inspection. Respondent agrees to allow ABCA investigation to inspect the entire premises of the business during the hours that it is open to the public to verify that the business is not selling these products listed in paragraph 1. 3, licensing. Nothing which notwithstanding paragraph 1 and nothing in OIC precludes respondent from applying for an alcohol license or a medical cannabis license, retail license. Number 4, lifting of the summary closure. The current summary closure shall remain in effect until the multi-agency cannabis enforcement team, MCET, including the Department of Licensing and Consumer Protection and the Department of Health, has inspected the entire premises. I therefore make a motion that the offer in compromise be accepted. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Number 3, review of an offer in compromise. This is in 25 ULC 00044, Denny's Liquors. And the offer in compromise is as follows. Products not to be offered, exchanged, or sold. Respondent confirms that it has ceased selling cannabis or cannabis products and agrees to not offer, exchange, or sell either in a store or online cannabis or cannabis products, including hemp and CBD, without a cannabis license inspection. Respondent agrees to allow ABCA investigators to inspect the entire premises of the business during those hours that it is open to the public to verify that the business is not selling cannabis or cannabis products without a license. 3, training. Within 30 days of the board approving the OIC, the respondent shall either attend the ABCA training entitled Medical Cannabis Amendment Act of 2022 Overview, or if not offered, view the recording that is presently published on ABCA's website titled MCAA General Oversight. Within 10 days of completion, respondent shall submit a certification or declaration to verify completing the training to ABCA at abca.legal.dc.gov. Failure to submit the signed certification shall be a violation of DC's Code Section 25823A6. Number 4, fine. Respondent agrees to pay a $2,000 fine for a violation of DC Code Section 25-823A1, which shall be deemed a first primary tier violation. The fine shall be paid within 30 days, or the alcohol license shall be suspended indefinitely until the fine has been paid. 5, lifting of the summary closure suspension. The summary closure and suspension shall be lifted once the board approves the OIC. 6, return of key. ABCA shall make the keys to the premises available to respondent for pickup at its offices or at another mutually agreed upon time, date, and location upon approval of the OIC by the board. I therefore make a motion that the offer in compromise be accepted. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. Number 4, review of offer in compromise. This is case number 25 ULC 00052, Minnesota Food Mart. Hold on, please, sir. Let me. And the offer in compromise for this case the briefing is incorrect, but the correct citation for this case is 25 ULC 00051, which is a Minnesota Food Mart. The OIC is as follows. Number 1, products not to be offered, exchanged, or sold. Respondent confirms that it has ceased selling cannabis or cannabis products and agrees to not offer, exchange, or sell either in the store or online the following products: cannabis or cannabis-deprived products, including all cannabinoids, hemp, CBD, tetrahydrocannabinolic, and THC-A and THC, kratom, and 3, any Schedule 1 substance, including psychedelic mushrooms and dimethyltryptamine, otherwise known as DMT. Inspection. Respondent agrees to allow ABCA investigators to inspect the entire premises of the business, including those hours that it is open to the public, to verify that the business is not selling cannabis or cannabis products without a license. 3, training. Within 30 days of the board approving the OIC, the respondent shall either attend the ABCA training entitled Medical Cannabis Amendment Act of 2022 Overview, or if not offered, view the recording that is presently published on ABCA's website titled ABCA General Overview. Within 10 days of completion, respondents shall submit a certification or declaration to verify completing the training to ABCA at abca.legal.dc.gov. Failure to submit the signed certification shall be a violation of DC Code Section 25-823A6. Number 4, fine. Respondent agrees to pay a $2,000 fine for the violation of DC Code Section 25-823A1, which shall be deemed a first primary tier violation. The fine shall be paid within 30 days of the board's approval of the OIC, or the alcohol licenses shall be suspended indefinitely until the fine has been paid. Number 5, lifting of summary closure suspension. The summary closure and suspension shall be lifted once the board approves the OIC. Number 6, return of keys. ABCA shall make the keys to the premises available to respondent for pickup at its office or at another mutually agreed upon time, date, and location upon approval by the OIC by the board. I therefore make a motion that the offering compromise be accepted. Is there a second?
Mr. Meadows, I second the motion.
Mr. Meadows, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
And Mr. Anderson, I agree. The matter passes 5-0. Number 5, review of offering compromise. This is Penn Smoke Shop. This is in case number 25 ULC 00054. The offering compromise is as follows. Products not to be offered, exchanged, or sold. Respondent confirms that it is ceased selling cannabis or cannabis products and agrees not to offer, exchange, or to sell either in the store or online the following products: cannabis or cannabis derived products, including all cannabinoids, hemp, CBD, tetrahydrocannabinolic acid, THC-A, and THC, kratom, and 3, any Schedule 1 substance, including psychedelic mushrooms, and dimethyltryptamine, otherwise known as DMT. I'll get it right one of these days. Respondent agrees to not offer, exchange, or sell alcoholic beverages without an alcohol license by the ABC board. Security. Number 2, security. Respondents agrees to only hire or contract security officers that are licensed by the District of Columbia. Number 3, inspection. Respondent agrees to allow ABCA investigators to inspect the entire premises of the business during those hours that it is open to the public to verify that the business is not selling those products listed in paragraph 1. 4, lifting of the summary closure. The current summary closure shall remain in effect until the Multi-Agency Cannabis Enforcement Team, MCET, including the Department of Licensing and Consumer Protection and the Department of Health, has inspected the entire premises. I therefore make a motion that the offering compromise be accepted. Is there a second?
Jones, I second the motion.
Mr. Jones, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn. Ms. Quinn.
Sorry, Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
And Mr. Anderson, I agree. The matter pass 5-0. All right, let's do all right. So let's now go to our licensing agendas. So we're going to do the alcohol licensing agenda. On this agenda, there are 6 applicants. I'm going to read all 6 recommendations and provide recommendations, and at the end I'll ask the ABC board members to approve the recommendations as put forth by the chair. Number 1, review application for safekeeping of license. This is the Great American Bistro, Oasis DC, license number 116742. The recommendation is to approve through March 31st, 2026. Number 2, review of application for entertainment endorsement inside of the premises only. This is for Tiffany's Bar and Bistro, license number 129463. The recommendation is for placard. Number 3, review application for change of hours. This is MXDC, license number 127757, recommendation placard. Number 4, review request for approval to provide a gift of prepared food items that does not exceed $500 in value to various licensed retail establishments. This is for Breakthrough Beverage, license number 124554, recommendation approval. Number 5, review request to approval to provide a gift of Fernet shot chiller machine that does not exceed $500 in value to various licensed retail establishment. This is from Republic National Distribution Company, license number 076499, recommendation approval. And number 6, review request to remove the entertainment and dancing endorsement from the license. This is for Sushi Sato, SATO, license number 131883, recommendation approval. I therefore make a motion that the ABC board approve the recommendation as put forth by the chair on the alcohol licensing agenda. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Janice and I agree. The matter passed 5-0. We now move to the Alqua licensing supplemental agenda. On the supplemental agenda, there are 6 applications. I will review the name all 6, give some recommendations, and at the end, I'll ask the ABC board members to approve the recommendation as put forth by the chair. Number 1, review request for temporary operating retail permit. This is for Throw Social DC, license number 133556, recommendation approval. Number 2, review request to remove the license from safekeeping upon approval and issuance of the transfer license. This is for Pub Key DC, formerly Hill Country, license number, the original license number is 133542. The new license number is 133542. The original license number is 083696, recommendation approval. Number 3, review application for class change from Retailer C Restaurant to Retailer C Tavern. This is for the Continent DC, license number 128701, recommendation placard. Number 4, review application for change of hours to live entertainment. This is for the Continental DC, license number 128701, recommendation placard. Number 5, review application for Sidewalk Cafe endorsement with 20 seats. This is for Trini Vibes, VYBEZ, license number 124738, recommendation approval. Number 6, review request to remove the street endorsement from the license. This is for Red Derby, license number 076076, recommendation approval. I therefore make a motion that ABC board vote to approve the recommendations made by the chair. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. We now move to our cancellation agenda. The ABC board will be canceling the following license for the reasons outlined below. Number 1, Law Society, license number 083420. The licensee did not pay the safekeeping fee within 30 days. I therefore make a motion that ABC board cancels this license. Is there a second?
Mr. Meadows, I second.
Mr. Meadows has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
And Mr. Anderson, I agree. The matter passes. 5-0. We now move to the board's temporary license and one-day substantial change docket. On this docket, there are 10 applications. I will review the name, the type of license, the event, the license number, and the attendees, and I will make recommendations. At the end, I will ask that the ABC board members vote to approve the recommendations as put forth by the chair. Number one, a request from Ella Guyet, Guichet. This is for one-day license class F for concert, August 23rd. The license number is 133569, 600 attendees, six security guards, recommendation approval. Number two, a request from Jessica Cardoso, Cardoso, for one-day license class F, birthday party, August 16th. The license number is 133504, 200 attendees, 5 security guards, recommendation approval. Number three, another request from Jessica Cardoso for one-day license class F. This is a wedding, September 13th. The license number is 133505, 150 attendees, 5 security guards, recommendation approval. Number four, request from Larry Weston, one-day license class F, reception, August 17th. The license number is 133521, 50 attendees, 1 security guard, recommendation approval. Number five, a request from Stuart Morris, one-day license class F, conference, August 13th. The license number is 133523, 100 attendees, 2 security guards, recommendation approval. Number six, a request from Millicent Hawkins, one-day license class G, dinner and dance, August 26th. The license number is 133510. 200 attendees, 4 security guards, recommendation approval. Number seven, another request from Millicent Hawkins, one-day license class G, birthday party, August 30th. License number is 133519. 70 attendees, 2 security guards, recommendation approval. Number eight, a request from Keith Shelby, one-day license class G, cultural food festival, September 20th. License number is 133499. 300 attendees, 8 security guards, recommendation approval. Number nine, a request from Jessica Zaluk, Zaluzec, one-day license class G, cultural food festival. This is December 11th. The license number is 133525. 150 attendees, 3 security guards, recommendation approval. And number 10, a request from Sene Teda, Tedla, one-day license class G, graduation party, August 31st. License number is 133553, 200 attendees, 4 security guards, recommendation approval. I therefore make a motion that ABC board members vote to approve recommendations as put forth by the chair for the board's temporary one-day substantial change docket. Is there a second?
Jones, I second the motion.
Mr. Jones has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. We now move to the board's alcohol licensing administrative docket. On this docket, there are 24 applications, and without objection, I make a motion that ABC board votes to approve this entire agenda. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones. Mr. Jones. Can't hear you, Mr.
I
Jones.
agree.
Mr. Anderson, I agree. The matter passed 5-0. We now move to the medical cannabis licensing agenda. On this agenda, there are 10 applications. I will review all 10 applications. I'll make recommendations. And at the end, I'll make a motion and ask that the ABC board members vote to approve the recommendations put forth by the chair. Number one, review of standard application to convert to conditional retail license. This is for Aloha. License number 129362, recommendation approval. Number two, review of social equity application for a new retail license with delivery endorsement. This is the the joint license number 129055 recommendation placard. Number 3, review of standard application for a new retail license with delivery endorsement. This is a good joint license number 129403 recommendation placard. Number 4, review of standard application for a new retail license with delivery endorsement. This is for Aloha, A-L-O-H-A. License number 129362 recommendation placard. Number 5, review of standard application for educational training and educational taste and endorsement. This is for District Cannabis, license number 126338, recommendation approval. Number 6, review of social equity application for expansion of retail license. This is for Wash Hydro, license number 126952, recommendation placard. Number 7, review of upstream entity change to Fido Cultivation LLC, license number 126338, recommendation approval. Number 8, review of packaging and advertising design. This is for Phyto Cultivation LLC, license number 117347 and 125104, recommendation approval. Number 9, review of packaging and advertising designs. This is for Creep Cannabis Company, license number 128924, recommendation approval. And number 10, review of reconsideration requests for extension denial. This is for Quality Control LLC, license number 121368. Recommendation denial because the application was part of the 150-point selection that were required to submit a corrected application by May 1st, 2025. I therefore make a motion that ABC Board vote to approve the recommendations as put forth by the chair for the medical cannabis licensing agenda. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. We now move to the medical cannabis licensing supplemental agenda. Review of social equity application for new internet retail license. This is for Local D, license number 127945. I make a motion that we approve this request. Is there a second?
Mr. Meadows, I second.
Mr. Meadows, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. And the last agenda item that we have this afternoon is the medical cannabis license administrative docket. There are 2 license applications on this docket. Without objection, I make a motion that ABC Board approve this docket. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 5-0. We're now at the end of our agenda item so that we can now go to our afternoon calendar. And I'm going to call our afternoon calendar out of order. So the first case I'm going to call is case number 25 ULC 00051 Minnesota Food Mart. This hearing is canceled. The board voted earlier this afternoon to accept an offer and compromise. The next case on our calendar is case number 25 PRO 00025 Nando's Peri Peri, license number 97889. This was supposed to be a protest hearing based on the time constraint. The board has administratively continued this hearing to a date to be determined. The next case on our calendar is case number 25 PRO 00045 Trade. This hearing has been canceled due to the withdrawal of the protests. And so the only case that we have now on our calendar this afternoon is case number 25 ULC 00053, presidential flights. And this is an unlicensed. So, Mr. Oriana, can you please elevate the rights of the parties in this case?
Thing. Bottle Dean, access elevated. Anthony Zello, access elevated. And I believe that's it, Chairman.
All right, thank you.
Hey, good afternoon.
Yeah.
Hold on 1 minute, please. Do you have a camera you can turn on, sir?
Right now, I don't. I have
All
on.
right, that's fine. All right, good afternoon, everyone. This is a summary here in action. I want to apologize to the parties. I know you guys have been waiting all afternoon for 1:30 hearing, but as you see, our afternoon calendar, our morning calendar stretched into this afternoon. The board had to take a lunch break, and we also had to do our agenda. So I apologize for our delay, but we now, you have the time now to listen to this case. So let's start with the government identifying themselves for the record, please.
Good afternoon, Mr. Chair, members of the board. Assistant Attorney General Anthony Cello on behalf of the government, ANTHONY CELO. I would also note that my witness, Supervisory Investigator Jason Crew, is here if his access can be elevated as well.
All right, thank you. All right, thank you, Mr. Cello. Mr. Dean, can you please spell and state your name for the record, sir?
Yes, Fidel Dean.
And who are you, sir?
I'm a resident of 2407 18th Street.
The reason I'm asking, sir, I mean, this is a summary action notice. So did you request a hearing for this matter? That's what I'm trying to find out, sir.
Yes, I would like to enter the primary residence as no court order paper stating otherwise, and I'd like to ask for a continuance till the outcome of the criminal case.
Mr. What's the government? So, all right. So you're asking for two things. So the first thing you're asking to continue this case. That's the first thing you're asking for. Is that correct, sir?
Till the outcome of the criminal matter.
And you're also asking for access to, because of this property been padlocked, and so you're asking for what? What else?
Basically, this is my primary residence, and under the tenant bill of rights, I'm able to, be in my residence till any court order paper or is stating otherwise.
What's the government's position on the request from Mr. Dean?
Yes, Mr. Chair. So this establishment is an unlicensed establishment under the code. I don't think there's any dispute about that. But if there is, the evidence will certainly demonstrate it in the hearing. Whether or not the establishment is also a residence is a separate question that is not contemplated under the code and does not justify entry into the establishment. The district would be willing to permit entry into the establishment to recover personal property, personal effects, but any tenant bill of rights concern that Mr. Dean is raising is the subject for landlord-tenant court and has no bearing whatsoever on this board's consideration of this unlicensed establishment's closure.
So the government is stating that they are willing to allow Mr. Dean to enter the premises to retrieve his personal effects until such time as this matter is resolved. That's the position of the government?
Yes, and subject to the establishment remaining summarily closed, the district would have no opposition to a continuance request. But the district strenuously objects to allowing the establishment to be reopened pending the outcome of the criminal case.
Mr. Dean, you've heard the government's position, and so where are you on, is that acceptable to you? If that's acceptable to you, the board will issue an order. If not, then we're moving forward with a hearing, sir.
Yes, so this is completely unreasonable as there was no signage, there was no anything.
Sir, Mr. Dean, hold on, please. I mean, we're not arguing. You're making a motion. You're asking you can argue. If we go to a hearing, you can argue, but you asked for two things, sir. You asked to continue this matter pending the outcome of the criminal proceeding, and you also stated that you wanted access. And so the government states that they don't have a problem providing you access to go and retrieve.
That's my primary residence.
Sir, hold on, Mr. Dean. I'm saying, so we have to go to a hearing because what you're asking for
Preliminarily.
Thank you very much, Mr. Jones, for some staying. The government is not agreeing to that, so we need to go to a hearing today. So I was just saying to you,
No,
you can
I'll just continue with the continuance, but what I'm stating is that, but I need access to get my property. That's it. And what I'm trying to say is that it's unreasonable what the finish is.
Mr. Dean, I'm hearing you speak and I'm hearing noise in the background. So this is what, if this is the agreement, sir, we can agree to continue this hearing. The government states that they would agree to grant you access to the premises to retrieve your personal belonging, but the pending what happens in court or whatever continuance that you're requesting, this location, I'll for a better word, will remain closed. So if you want to agree to that, I mean, we can dispense with this hearing today. If not, we have to move forward with the hearing, sir. So it's not a matter of, I don't know the facts of the case, sir, for me to say whether or not it's reasonable or unreasonable. You've made a request. I've requested from the government what's their position, and they've informed you what their position is. If you accept what the government offers, we can dispense of this hearing today. If you're not in agreement to accept what the government offers, then we're going to have a full hearing today, and then the board will make a determination whether or not we're going to lift the suspension or whether or not we're going to continue it. So you let me know what it is that you want to do. So it's not a matter of the board is not taking testimony at this juncture. This is just, you made a request, the government made an offer, and it's like, is this offer acceptable to you? If it's not acceptable to you, we're going to go to a hearing.
Okay, I'm gonna accept the offer, and I just want to know the terms of the access. It will be what the terms of the access and time frame that I have been allowed.
This is something that you can negotiate with the government.
Okay.
So the bottom line, what's agreed to today is that we'll continue this hearing because you stated that there is you said there's a pending criminal case. So we can continue this case prior to that conclusion. The government has also agreed to allow you access to the premises. What this means is that the understanding is that this premises will remain closed. And I don't know what it is, sir. So I'm not going to say it's your residence or it's not a residence. As far as as far as all the information that the board has, it's this location. So the location will remain closed. However, you will negotiate your access to the location with the government, but the location will remain closed.
Mr. Chair, if I may make a representation?
Yes, Mr. Silo.
I can represent that the district will allow reasonable access, one-time access to recover his personal belongings, and that the access would be available as early as this Friday afternoon. And that would be for the personal belongings.
Is that acceptable to you, sir?
No.
What is it that you want me to do, sir? Because as I said before, I'm not going to because I don't know the facts and circumstances of this case, so we're not going to litigate it. So it's either you, if one of the things I can do, sir.
I just
I
need
can,
reasonable time.
hold on, Mr. Dean. This is what I can do. The board can go in executive session. All right. You and Mr. Silla can discuss this. If there's an agreement reached, you tell us what the agreement is, and that is fine. So rather than you negotiating with the board, negotiate with the government. If you guys can come to an agreement, then we'll dispense of this today. If not, if you cannot have an agreement, we're going to have a hearing. So what we can do is that the board will leave this hearing, go into executive session, and Mr. Silla, you can alert us by just putting on the chat, and I'll have our IT person will let us know when we can come back. Is that fair? Mr. Dean, is that something that you want to do that you can?
Yes.
All right, sir. So the board is going to log off. We're going to go in executive session. The parties can let us know when you are ready to move forward, okay? So you guys can stay on. We're going to go in executive session, and you guys can let us know when to come back, okay? All right, thank you. You stay on, and your Mr. Silla can negotiate, sir. All right, thanks.
Mr. Dean, I will give you a call on your cell phone.
Okay.
All right, thank you.
much. Anything
All right, we're back in the record. Are you there, Mr. Dean?
Yeah, I'm here.
Yeah, one of the reasons why I always ask folks to be on camera, and I know you are unable to be on camera, so I don't have to ask you the question if you're there. So that's the only reason why I always ask folks to be on camera. All right, Mr.
Chairman,
Phil, I'm sorry, who's asking the question?
there's no court reporter.
What happened?
Not sure. I'm gonna check with internally.
Okay, thank you, sir.
Still waiting, Chairman.
All right, thank you. I guess let me ask you, Mr. Silla, did the parties reach an agreement?
Yes, yes, Mr. Chair. When we do go on record, we will be agreeing to a continuance, and we have a schedule at least partially worked out for access to recover personal effects.
I'll wait another 3 minutes because this is going to be short. So I believe, and because this matter is been recorded, I think that we can move forward without a court reporter. But I'll wait. It's 4:38. If a court reporter doesn't appear by 4:40, we will just move forward since this matter has been recorded, so we can quickly capture what was agreed to today. I don't know why the court reporter left, because it was clear to everyone that we had not ended the day.
Long day for the stenographer too, Mr. Chair.
I am aware. I am aware. It's my understanding the court reporter is there, but they're having an issue. I don't know what the issue is that they're having. So let me get some further clarification to see what issue the court reporter is having. If not, I'm just waiting for whether or not legal can tell us too. All right, so I'm going to move forward. The court, I don't know what's going on with the court reporter, but this matter has been recorded, and so it should not be a problem in figuring out what in having a record of what happened today. So this case is case number 25 ULC 00053, presidential flight, and the request was that by the requestee, I think Mr. Dean, he had requested a continuance, and he had also requested access to the property. We went off record for the parties to have a conversation, and so Mr. Sila, has an agreement been reached there on what's been requested?
Yes, Mr. Chair.
What is it, sir?
The parties are willing to continue the case pending the resolution of the criminal case that is associated with the arrest stemming from this incident. The establishment will remain summarily closed pending the outcome of this case. The district has agreed to grant limited access on Friday and longer access on a future date to be determined for the recovery of Mr. Dean's personal effects.
Mr. Dean, is that acceptable to you, sir? Is that the agreement that you agreed to, sir?
Yes.
All right. Well, thank you. Well, I'm glad that the parties are able to resolve this. And with that said, this matter is adjourned. Thank you very much. Have a great day.
Thank you, Mr. Chair. Members.
You're welcome. All right. Thank you. And with that said, I believe that we have now concluded all business for the day. And so therefore, I will close the record for the day. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, in accordance with Title III, Chapter 405, Office of Open Government, I move that ABC Board hold a closed meeting on September 10th, 2025, for the purpose of discussing and hearing reports concerning ongoing or planned investigations of alleged criminal or civil misconduct or violations of law or regulations, and seeking legal advice from our legal counsel on the board's investigative agenda, legal agenda, and licensing agenda for September 10th, as published in the DC Register on September 5th. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
And I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. As the motion has passed, I hereby give notice that ABC Board will hold this meeting pursuant this closed meeting. Pursuant to the Open Meetings Act, notice will also be posted on the ABC Board Hearing Room Bulletin Board, placed on electronic calendar on ABCA's website, and published in DC Register in as timely a manner as practical. We're adjourned for the summer. We have no scheduled meetings again. Our next scheduled meeting is September 10th. However, I believe that the board will meet prior to September 10th. Anyway, thank you all for your active participation today. And we're now adjourned. And I ask all board members to return to executive session for further action. Good afternoon. Thank you.